Good evening. What was your progress? Good evening, welcome to the December 13th, 2021 meeting of the Nutley zoning board of adjustments. Please stand for the flag salute. I pledge allegiance to the flag of the United States of America, and to the republic which stands one nation under God, indivisible, with liberty and justice for all. Secretary, please read the lights regarding public meeting.
Pursuant to the requirements of section 13 of the Open Public Meetings Act, notice of this meeting was included on the annual notice of regular meetings for the year 2021. It was advertised in the Nutley Sun with a copy posted on the town of Nutley bulletin board, first floor, 1 Kennedy Drive, Township of Nutley, New Jersey, with a copy sent to Herald News. A copy is filed in the office of the township clerk, and copies are made available to all persons requesting same. Public comments. All persons addressing the zoning board of adjustments regarding community concerns should approach the microphone and provide their name and address for the record. Unless further time is granted by the board, each person shall limit their address to 3 minutes. All remarks to the board and its individual members must be addressed to the chairman. The chairman may defer citizen comments to the appropriate member of the board. Dialogue between citizens and others addressing the board shall be allowed unless the chairman or presiding officer or the majority of the membership of the board shall determine that the interest of the decorum and or the expeditious conduct of the board's business are being adversely affected by such dialogue. Ms. Dougherty? Here. Mr. Capone? Excused. Ms. Castro? Here. Mr. Scheidel?
Here.
Mr. Daniel Tovey?
Here.
Ms. Duva? Excused. Ms. Wallace? Here. Mr. Gregory Tolby? Excused. Mr. Battaglia?
Here.
Mr. Graziano?
Here.
Diana Powell McGovern? Here.
Thank you. I'll call your name, just let us know that you're here, ready to go. 127 King Street.
That is being adjourned until January 10th, 2022, our next regular meeting. We did not believe that we were going to have enough board members to facilitate the use variance, so that was actually, I need to get more
Motion to adjourn to January 10th.
Yes.
All in favor?
Aye.
82 Ridge Road.
There was a question raised, there's an objection to this application, and the attorney who's representing the objector raised a code interpretation question of sorts. I couldn't get to Mr. Berry because he's battling COVID and sick and doesn't have a file home with him. So I explained to the applicant, he has consented to an adjournment to the January date of January 10th, 2022.
So we need a motion to adjourn that to January 10th, 22. All in favor?
Aye.
Opposed? 150 Metro Boulevard. Present. 11 East Center Street.
Present.
142 Nutley Avenue.
Present.
Okay. Let's start 150 Metro Boulevard.
There is no letter.
Good evening, Merrill Gonsher with the firm of Sills, Cummins and Gross. We are the applicants for DD Nutcliff Master LLC. The applicant this evening and the owner of the property, which is the subject of the application this evening. Notice was sent to all interested parties back on November 5, 2021. Notice was published both in the Star Ledger and the Herald News. Affidavit of proof of service was submitted to the board on November 11, 2021. And this matter was previously before the board on November 15. It was carried at that time with no further notice required. Just confirming that the proof was submitted and Mr. Governor had reviewed that previously. I believe it was carried on the.
Yes, it was.
Thank you. No further notice was required. This matter derives from an application that was originally submitted to the planning board back on February 22, 2021. Through the course of the application, as I will explain in more detail, a question was raised as to whether a use variance was required for the use of the private roadway known as Road D. We are here tonight seeking an interpretation of the code of the township of Nutley pursuant to NJSA 40:55, capital D, 70D, to confirm that Road D is a permitted use and no D variance is required in order to allow final site plan approval to be granted to Road D, notwithstanding that Road D was subdivided from lot 1.01 and was approved as a separate parcel. To the extent necessary, the application also included in the alternative an application for a use variance and final site plan approval to permit the use of Road D. And if permitted by law, final site plan approval for the 7-level parking garage, 23 at-grade parking spaces in courtyard that will serve the existing buildings known as 100 Metro Boulevard and 200 Metro Boulevard. That 7-level parking garage is located at 150 Metro Boulevard, and also for approval of Road H, which is located on the same lot with 150 Metro Boulevard. Tonight, we would like to proceed first with the interpretation, and only if the board does not find that no use variance is required will we then proceed to a D1 variance. By way of background, the Nutley Planning Board previously granted preliminary and final major subdivision approval and preliminary site plan approval to former block 201, lot 1, back on September 5, 2018, as memorialized by 2 separate resolutions dated September 19, 2018. Recall that the board granted preliminary and final subdivision approval at that time, and preliminary site plan. On August 14, 2019, as memorialized by a resolution of even date therewith, the planning board granted amended preliminary site plan approval for the construction of private access roadways identified as roads D and H on plans filed with the board, recognizing them as accessory uses to portions of lot 201, lot 1. Bear in mind also that this approval was granted after final subdivision approval had already been granted with regard to this project. At that time, there was no issue as to whether Road D required a use variance. The board made no such finding at that time. Road D services existing buildings and other private roadways on the On3 campus, including 100 Metro Boulevard, which we often refer to as the Ralph Lauren building, 150, which is the parking garage that serves 100 and 200 Metro, and 200 Metro Boulevard, which is under lease to, I'm going to mispronounce it, Eisai, a Japanese pharmaceutical company. The subdivision of former block 2001, lot 1 was perfected by the recording of the subdivision in December 2019. The planning board then granted a further amended preliminary site plan approval for 100, 150, and 200 Metro Boulevard and roads D and H to phase the project, and at the same time granted final site plan approval for 100 Metro Boulevard on February 5, 2020, as memorialized by resolution dated March 11, 2020. The phasing was specifically to allow the applicant to seek and obtain final approvals with regard to the individual lots. Again, no issue was raised with regard to whether Road D required use variance. Road D has since been built and all of the necessary improvements have been made. On February 22, 2021, the applicant submitted an application for final site plan approval for the 7-level parking garage, 23 at-grade parking spaces, and courtyard that will serve 100 Metro and 200 Metro Boulevard. Property located at 150 and 200 Metro Boulevard and roads D and H. At the time of the February 22, 2021 application, the Nutley Hoffman LaRoche Phase 3 redevelopment plan, roadways and circulation, was in place and specifically identified Road D as a permitted roadway. In fact, it recognized that Road D was specifically intended to serve the properties within the Phase 2A redevelopment area, which include 100, 150, and 200 Metro Boulevard. The application was deemed complete, and then the applicant was scheduled to appear before the planning board on June 2, 2021. The zoning officer, who's the appropriate official to determine which variances are required for an application, did not determine that a use variance was required for Road D. In fact, the application was initially filed without roads D and H, and Mr. Berry is the one who suggested that final site plan for those two roadways be included in the application for final site plan approval of the garage, which is 150 Metro and 200 Metro Boulevard. Paul Rickey issued a review letter dated May 17, 2021, questioning whether a D1 use variance was needed for Road D because it is located on a separate lot since perfection of the subdivision from the uses and buildings it serves. Mr. Rickey did not determine that a use variance was required, but rather simply raised a question. Mr. Rickey also laid out an interpretation where a D1 use variance was not needed based on the definition of the word lot not being limited to tax lots as set forth in the municipal land use law, which he cited. At the planning board meeting on June 2, 2021, the planning board questioned whether a D1 use variance was required for Road D. I will note that the Phase 3 redevelopment plan was still in place at the time that we appeared before the planning board on June 2, 2021. The planning board would not proceed until the zoning board determined whether a use variance was required for Road D, and the matter was adjourned. The applicant then submitted its application to the zoning board on August 23, 2021, and we are here seeking an interpretation that a use variance is not required for Road D, consistent with one of the two interpretations that Mr. Rickey put before the planning board back when we appeared before them in June. Road D was approved as an accessory use to the principal uses on former block 201, lot 1, which includes 100, 150, and 200 Metro Boulevard. The definition of an accessory building or use in section 700-3 of the Code of the Township of Nutley is a building or use clearly incidental and subordinate to the principal use or building and located on the same lot with such principal use or building. The definitions of lot in section 700-3 of the Code of the Township of Nutley and NJSA 40:55 capital D-4 make it clear that the word lot, including when used in the definition of accessory building or use in the Code of the Township of Nutley, is not limited to a tax lot on which the accessory use is located. The definition of lot in section 700-3 is a parcel of land having frontage on a street and occupied or capable of being occupied by a building or buildings, together with the open space appurtenant to such building or buildings. It then has an exception with regard to subdivisions approved after January 1, 1979. The definition of lot in NJSA 40:55 capital D-4 is a designated parcel, tract, or area of land established by plat or otherwise as permitted by law and to be used, developed, or built upon as a unit. There is no question that Road D is being developed as a unit with the principal buildings and uses which it serves in a phased project. This is clear from the 2 amended preliminary site plan approvals granted by the planning board, which included Road D in the larger development. Therefore, while Road D may be on a separate tax lots from the buildings and uses which it serves, Road D is still part of the same development lot as the principal buildings and uses, as it forms a coherent area of land or parcel which is being used and developed upon as a unit. Because Road D is a permitted accessory use, a use variance is not required. Road D provides the access from the parking garage located on one of the lots, which is known as 150 Metro Boulevard. In addition, at the time of the application to the planning board, private roadways were a permitted use under the Nutley Hoffman LaRoche Phase 3 redevelopment plan, roadways and circulation. And Road D was identified in the plan as a permitted use as an access road. Access roads in that plan were specifically designated to serve buildings and uses in the Phase 2A redevelopment plan area, which Road D does. 150 and 200 Metro Boulevard are in the Phase 2A redevelopment plan, and Road D services those buildings. While the Phase 3 redevelopment plan has since been overturned by the courts, New Jersey has codified the time of application rule in section 10.5 of municipal land use law. The time of application rule means that the zoning in place at the time the application was submitted controls the application. Although courts have held that if the zoning changes during the course of the application to the benefit of the applicant can take advantage of the new zoning. Therefore, under the time of application rule set forth in NJSA 40:55-10.5, Road D should have been considered a principal permitted use at the time the application was before the planning board. Finally, there's a third reason why a use variance is not required for Road D. As explained earlier, the applicant was granted amended preliminary site plan approval on August 14, 2019 for the construction of Road D as well as Road H as an accessory use. The applicant was then granted amended preliminary site plan approval on February 5, 2020, including for Road D and to phase the overall project. If the board states that the subdivision was not perfected at the time of the amended site plan, if the subdivision was not perfected at the time of the amended site plan, the perfection of the subdivision is of no moment. It holds no legal weight. The subdivision had already been approved, both preliminary and final, at the time the board granted the amended site plan to approve the road. Therefore, and at the time of the second amended preliminary site plan when the phasing was approved. Therefore, at all times relevant, the planning board had already granted the subdivision approval, which created the separate lot where Road D was located. And therefore, the board acted with that knowledge that it still remained an accessory use because of its operation and function in relation to the buildings at 100 and 200 and 150 Metro Boulevard. The application for final site plan approval was filed, as I indicated, on February 22, 2021. It was within the 3 years of vested rights which attached to an approval from the last amended preliminary site plan approval, and this has been confirmed by the planning board. Therefore, the applicant is protected for 3 years from the grant of preliminary site plan approval from any changes that would require a use variance under NJSA 40:55D-49A. That section of the municipal land use law provides preliminary approval of a major site plan shall confer upon the applicant the following rights for a 3-year period from the date on which the resolution of preliminary approval is adopted. That the general terms and conditions on which preliminary approval is granted shall not be changed, including but not limited to use requirements, layout and design standards for streets, curbs and sidewalks, lot size, yard dimensions, off-track improvement, and in the case of site plan, any requirements peculiar to the site plan approval. Therefore, the grant of the preliminary site plan approval establishes the rights as to the use of Road D in conjunction with the development of 150 and 200 Metro Boulevard. At no time was the grant of either preliminary and final subdivision or preliminary site plan approval for 100, 150, and 200 Metro Boulevard conditioned upon the grant of a use variance for the use of Road D or any of the above applications. Therefore, the state of the law that existed at the time of the grant of the previous approvals expressly recognized that the use of Road D was a permitted use accessory to the buildings and properties which it serves. As such, the law in existence at the time of the grant of the approval was frozen pursuant to the MLUL, and no use variance was required by the planning board as a condition of any of its actions taken in approving the subdivision and the site plan. Lest there be any question, the law recognizes that the MLUL protections to which I have referred applies to site plan approvals granted in redevelopment areas, so there is no exception. Therefore, a use variance is not required for Road D because the preliminary site plan approval granted 3 years of vested rights from the most recent amendment, and it was not conditioned upon obtaining a use variance. And the final site plan approval was filed timely. For these various reasons, in other words, 3 separate theories, all of which militate against the need for a use variance with regard to Road D. Now, we have 2 witnesses with us this morning. This evening. I'm going to start the day early. It's been that long. So we do have our engineer. Our purpose in presenting him with regard to the interpretation is only for him to identify some of the plans which we've colored up that we hope will make it easier to understand where the roads are located in relation to the properties. And we'll ask him to identify as well as confirm some of the information that I have put in by way of legal presentation and argument. We also have our planner who will provide testimony this evening. And we have brought some other exhibits. I have referenced the phase 3 redevelopment plan, which although it was invalidated by the court, at the time we were before the board, it was in effect. We have the relevant pages that provide the definition of what an access road is under that plan. And our purpose of presenting it is that merely confirms our assertion that Road D has always been viewed as accessory to buildings 100, 150, and 200 Metro Boulevard. That's how it was approved, that's why it was approved, and under the appropriate definitions of lot, it remains accessory to those uses in buildings, and therefore no use variance should be required. If I may, I'd like to call Mr. Chu, our engineer, who can introduce those plans. Where? I know this is a new one for everybody. Where do you think it needs to work? By that door?
You can spread out a little bit, so.
Do it in the middle.
Show
Yes, right in the center.
Right in the center.
Right in the center? Okay. Oh, blocking.
No, right.
Yeah, I got them, just want to make sure it doesn't block.
Oh, it's on the top, okay. You'll let us know if we're blocking things.
Did you print markers already?
Unofficially, we were guessing, I had gone through with you what you consider part of the record.
I see one is marked exhibit A1.
Well, yeah.
I want to see what he's presenting, I can't see.
No, I'm asking if you want to.
Oh, wait, I have something.
You should have gone to the different one. This one goes like that, I'm sorry. Did you want secretary want to mark? Yeah, sorry.
Can you give us your full name, spell your last name and address?
My name is Jiajing Xu, first name is spelled J-I-A-J-U-N-G, last name is spelled C-H-U. I'm currently employed by Bluebird Farrell in Somerville, New Jersey.
Can you give us some of your background?
Sure. I received my bachelor's degree from NJIT back in 2003, and I received my professional engineering license in 2010. I've been working as a civil engineer for over 15 years now. During my career as a civil engineer, as a licensed engineer, I have testified for other boards, such as the Greenville Township, Hamilton Township, State County, and most recently is the city of Clifton. This is my first time here in Nutley, so you should be accepted as an expert in field engineering.
Okay, so
Thank you for accepting him as an expert in the field of engineering. Okay, can you identify the items that we presented? Mr. Governor, I just wanted to ask, everything in this previously been submitted is considered part of the record, do we need to mark anything that you already have?
Well, if you're gonna highlight something and have it,
That we
we'll
will.
talk about it, we more.
Right, but you know, some boards go through and mark every piece of the application.
No,
That's why I didn't know what number to start with.
No.
Yes, that's all.
A1, everything, we just mark it from when you have your testimony.
All right, so in that case, the document, Justin, that is on the board, and which we handed out in 11 by 17, which is comprised of 3 sheets. Is that the same document that was submitted as part of the application, the as-built survey?
Yes, it is actually so that you can verify it.
Right, so we did not, that one was not colorized.
That's not.
Okay, actually, I didn't have a copy. But this is the same plan in reduced format from what was submitted, so I trust that we do not need to mark that, unless you want us to.
Again, if you're going to ask him to comment on it, mark it as an exhibit so that it's clear in the testimony what part of the application we're talking about.
So it's 3 sheets, we'll mark that A1 with today's date. With the note, and let me ask you, Justin, if you can identify the date on the plan and the title of the plan.
Sure. The current plan is as-built survey for 200 parking garage and surrounding area, again prepared by Malcolm Layout. The drawing date is July 13, 2021.
Okay. And just so we all understand what this is, am I correct that in Nutley, site plan approval is granted after the improvement? Site plan approval granted by the planning board, I won't speak for this board, requires the improvements to be constructed, and then final site plan approval is sought once an as-built survey is submitted.
That's correct.
Okay, and this was the as-built survey that was submitted to the planning board in conjunction with the February 2021 application for final site plan approval.
That's right.
Okay. Can we also then look at the other plans so that when we speak about the approvals that were obtained, we can reference them perhaps by color. This is a document, this is on the board. It's a black table, step on it, sliding off. Can't be tracked, right? I would have wanted slides if I was. Just saying. Okay, all right, Justin, can you identify what's on the easel now, and not by the exhibit we gave it?
Okay.
What's the document?
So the document in front of you is titled Green Roadway, which is basically the phase plan of this application. It is a colorized rendering for basically display all the lot within this application, as well as the roadway that will be discussed over this period.
Okay, and I'm gonna be, although it says exhibit A1 on the bottom, I will mark this A2 with today's date. All right, and can you just walk us through and identify the different parcels by their color as depicted on A2? So that when we ask about approvals that were given and we reference them, they'll be in context.
Sure. Right, the road in question, which is road B, that is entirely within the lot that's highlighted in blue. That's known as a block 201, lot 1. And then the 150 Metro Boulevard, which is known as Metro Garage, is within the parcel that's highlighted in yellow. That's known as the block 201, lot 1.01. And the existing building, known as 100 Metro Boulevard, is within the parcel that's highlighted in green. That's known as block 201, lot 1.03. 200 Metro Boulevard, highlighted in pinkish color, is known as block 201, lot 1.02. Within the lot 2.01, lot 1.01, there is a constructed roadway known as road H, that's highlighted in brownish color.
Okay, and am I correct that the only application for which an interpretation to determine to resolve the issue of whether road D requires a use variance, and which we assert does not, is the road that is in blue?
Okay, that's right.
Okay. Now, were the roadways, both road D and road H, granted preliminary site plan approval by the planning board of the township of Nutley as part of the amended preliminary site plan approval.
Yes, they are.
Okay. And was the applicant required to provide as-built plans or survey as a condition to obtain final site plan approval with regard to these improvements?
Yes, that's part of it.
So that the improvements were constructed as of the time that the application for final site plan approval was sought?
That's correct.
And roadway D as well as road H had also been built at that time?
Yes, they have been done.
And just as, have they been inspected in the course of construction?
Yeah, they have been inspected by the township.
Now, when the as-built plans were submitted, to the planning board for final site plan approval, were the plans reviewed by the planning board engineer and comments provided?
Yes, we have received comments.
Okay, and were the comments addressed, and are the comments that were received from the planning board engineer reflected in the plans that are before, that we refer to here as the as-built survey?
Yes, the survey that in front of you is reflecting the comment that we addressed.
Okay. Both roads then have been constructed, road H. Let me ask this, road H is not an issue, there's no question has been raised with regard to road H and use variance. Can you explain the difference that has been identified, or which the planning board has identified as a difference between road H and road D?
As far as we know, again, as mentioned before, is this whole separate lot. However, as I explained earlier, that it was serving the provided access to the 100 Metro Boulevard, as well as provide a full circulation of the vehicle, now fire department, and as well as trucking, be able to access to 100
I'm sorry,
The fire truck's gonna go, so I just.
so hold on.
Oh, this is exciting.
Yeah.
I was having a hard time hearing you.
Oh, I'm sorry.
Just,
Oh, it's the noise.
yeah, you're welcome.
And Yuri.
Okay. So I was saying that, really the proposed, use for road D is to provide access, into 150 Metro Boulevard. And also more importantly, that it actually provide a full circulation vehicle, such as a fire truck, and the delivery truck to be able to get to, the building 100 Metro and 200 Metro.
So from an engineering as opposed to a legal or a planning perspective, would it be your testimony then that that road D, as with road H, is part of a development that has been built as a unit?
Yes.
Okay. You testified that its purpose is to provide general circulation through the site. Is it also your testimony using exhibit 2 that one of the means of egress from the parking garage is onto road D?
Yes, that I can point to the access that we're referring to, that from, you will be getting from road D into the parking garage at this point. Essentially the rear entrance of the metro garage. And that serves as the
And just for the completeness of the record, road H provides another means of access to the.
That's correct. in road H does have another opening that will able to access to 150 metal, or the metal garage.
In terms of operation, then H and D function exactly the same in relation to the properties which they serve and to which they are accessory.
That's right.
That is all we have on direct for this witness.
Questions from the board for this witness?
Mr. Chairman, I have a question.
Sure.
If at some point in the future in lot 201, lot 101, if new buildings are built in that section, will this be applicable and pertain to those, or will that require an additional amendment to the application?
I'm not sure. What shows as yellow is fully developed.
It's fully developed.
That is the garage.
It is,
That, okay,
If you look, is it clearer on the,
up to the Clifton line.
yes, actually the garage crosses the Clifton line. It's built in both towns. It was granted site plan approval in both towns.
Thank you.
So that is not rated land. It just looks like a big piece of yellow. But if you look at the asphalt, you'll see the big garage there.
Thank you.
Any other questions? Anyone in the audience would like to question this witness? Thank you.
thank you.
Our next witness is our planner. I didn't know that.
So the testimony about the two cultures,
I do.
can you give us your full name, your address? Spelling your business.
Absolutely. My name is David Novak. That's spelled Novak. I am an associate principal with Burgess Associates. Our office is at 25 Westwood Avenue, in Westwood, New Jersey, 07675.
And he's been before us before.
And virtually, yes, but I am still a professional planner in the state of New Jersey, still a member of the American Institute of Certified Planners. I think the last time I was in front of you was virtually though.
Yeah, but I think you.
Yeah, you have been, so.
It's 275.
Yep.
Maybe we should remind you.
Agree.
Okay. So, you would ask, I don't know, you asked that you recognize him as an expert in the field of planning.
Yes, we.
Thank you.
Okay. I wanted to provide a couple of documents. We have referred to the Hoffman LaRoche Phase 3 redevelopment plan roadway and circulation, which was in effect when we were before the board and which sets forth some information. I don't know if the board has copies of this. I brought a number of them, but what's important is I have taken out the pages that have the language which we referred to.
This is what again?
This is the township's Phase 3 redevelopment plan, entitled Hoffman LaRoche Phase 3 redevelopment.
This is the one that was thrown out by the courts, but what you say was in place when preliminary was granted.
Yes.
All right, and this board doesn't have that.
Well, we have, I don't think we're gonna sit and read them. We wanted you to have that, and what we've done, we have referenced the language from there which defines them, and we have the applicable pages. So you have the document, you can, I have five of them, and mark your student or former plan.
I'll take one, and I think that put one on each side, the board member has curiosity to see it in full.
We can mark that as A3 if that,
Sure.
I apologize, I'm sure they were, but I. Now, what I've also done, since I referred to the language in it, is I have pages 10 and 11, which describe the area covered by it, as well as page 19 and 20, which have the definitions that I referred to. So I think those would be 84 with today's date. Because we keep referring to language. I would invite you to reference that, and mention it, so that we can put that into the record. Okay, why don't you, just reiterate why we're here, and then since we're starting with the interpretation, we hope the board will agree with our interpretation, and no variance is necessary, and we will be able to make it a short evening without having to go through these variance groups. So, I would ask you, Dave, to just start with the description of the nature of the relief that's being sought, and then, what's being considered in terms of the interpretation.
Absolutely. Before I continue, can everybody hear me all right with the test? Just wanted to make sure. Thank you very much. Again, my name is David Novak. I'm a professional planner and I'll be providing testimony tonight. As Ms. Gotcha alluded to, this is essentially a twofold application. So first, we're seeking interpretation pursuant to NJSA 40:55D, that's 7D, to confirm that road D does not require D1 use variance relief. Alternatively, though, should the board not agree with that assessment, we will then be requesting D1 use variance relief for that purpose. So first, I'd like to begin on the interpretation. And Ms. Gotcha pointed out there are really three aspects I'd like to consider for this application. The first would be the definition of accessory building or use, as well as the definition of lot. The second thing would be the prior zoning of the site, which we did discuss as the phase 3 redevelopment plan. And then the third aspect would be vested rights in prior site plan subdivision rules. But first, let's begin with the definition of accessory building or use. And that's established in section 700-3 of your ordinance. And I'll read it out loud, and you'll see that's not necessarily an uncommon definition of that term. The definition is, quote, a building or use clearly incidental and subordinate to the principal use or building and located on the same lot with such principal use or building. One of the key provisions of that definition is that it must be located on the same lot. Thus, it's important to understand how lot is defined, not only by the township, but also by the municipal land use. So the township defines lot as follows: quote, a parcel of land having frontage on the street and occupied or capable of being occupied by a building or buildings, together with open spaces pertinent to such building or buildings. Municipal land use law definition is slightly different, but not too different. It's, quote, a designated parcel, tract, or area of land established by a plat or otherwise as permitted by law and can be used, developed, or built upon as a unit. So in both instances, neither the township definition nor the municipal land use law definition restrict or equate a lot to being the same as a tax lot. So the township identifies it as being a parcel of land, which we can interpret as a piece of land developed. Municipal land use law goes a little bit further to identify it as a parcel, tract, or area of land. And it is particularly clear. Is that the door open again? Sorry. So I don't, yeah.
Come back down, there's no
So they won't be used inside.
You just have to speak loud.
Sure. So it's particularly clear that the intent of the municipal land use law is to treat lot as an area to be used to develop as a unit. And I believe that the approvals by the township planning board exemplify this intent. So Road D was approved not to function in a vacuum on its own, but rather it was approved and constructed to function as a unit in association with the parking garage, as well as Metro Building 100 Metro Building 200. We just heard engineering testimony that road B provides access into the parking garage. It is also an integral function to provide firefighting capabilities, coincidentally since we're here, by providing access to the side of the building. So the fact that it's on its own separate tax lot does not mean it's meant to be its own quote development unit. Furthermore, based upon the layout of the tax lot which road B is located, I don't think it's necessarily capable or let me rephrase that. I don't think it's both occupied or capable of being occupied by a building or buildings together with open spaces pertinent to such building or buildings as defined by the township ordinance. And I believe that the planning board had recognized that at the time of preliminary site plan approval, as this lot had required a lot depth variance, where 150 people were required, and only 25 people proposed and then approved. So I believe it was understood at that time that this was not meant to be a building lot. So in consideration of this, I think it's appropriate to recognize that this lot was not meant to be a separate building lot, thus meeting township definition. I think it's appropriate to consider that as an area to be developed as a unit, and thus meeting the municipal land use law definition. And therefore, I believe we satisfy the requirements of the township's ordinance that the accessory use is on the quote same lot.
Okay, let me just jump in for a second. In the definition that you read for MLUL, it refers to an area of land established by a plat. Now, while the term plat is often used in connection with a subdivision plat, I'm going to read the definition from 40:55, capital T-6, definitions P to R, where plat is defined by statute as plat means a map or maps of the subdivision or site plan. Okay, and therefore, it follows then that the roads D and H together with the lots were shown on the site plans, and therefore further support your assertion that it is a lot within the meaning, that lot within the meaning of MLUL is not coincident with a tax lot.
That is correct, yes. Now, moving beyond the township present ordinance, I think it's also important to discuss the second aspect of this, which would be the phase 3 redevelopment plan. Ms. Gottschalk got through the sequence of the application events, which I won't reiterate altogether, but just to recap a little bit. Back on February 23rd, 2021, the applicant submitted an application for final site plan approval for the garage, 23 at-grade parking spaces in the courtyard, 100 Metro Boulevard, 200 Metro Boulevard, and roads B and H. That application is deemed complete and was scheduled to be heard at the June 2nd, 2021 planning board hearing, where the question of the D1 use variance was ultimately raised. At that time, the phase 3 redevelopment plan was in effect. And the phase 3 redevelopment plan specifically included road B. It established access roads as a permitted use. And in the definition of access road, it recognized that it was to serve uses located wholly or partially in Nutley and services approved in the phase 1 or phase 2 redevelopment plan. So
For reference, is that definition in section 6.2 on page 19? The definitions, the first one says access road.
that is correct. Again, it's on the bottom of page 19, under section 6.2, and continues on to page 20.
And though it's hard to see in the black and white under 6.1, where the map is, there is sort of a dashed black line that follows along, I'll say to the right, but it does have some direction, of the rail, the skinny line that is the railroad.
That is correct. You can see that on page 19, and also page 10, under section 4.1. The phase 3 redevelopment plan had straddled I believe that's the easterly side, or we'll call it the right side of the rail line that cuts through the total redevelopment area.
And so the definition of access road, which includes road D, specifically defines it by its service to phase 2A redevelopment plan area, and are all of the lots that we've been speaking about, 100, 150, 200 Metro, the 2 office buildings as well as the garage, all part of the phase 2A redevelopment plan area?
Yes, they were all approved pursuant to that plan as permitted uses.
Thank you.
So, as Ms. Gosser had mentioned before, in consideration of the phase 3 redevelopment plan being active at the time of that planning hearing, we need to consider the protection under the time of application. So as a little bit of a background, in 2010, the time of decision rule was eliminated for municipal planning law. That previously established rule had favored municipalities during the hearing process by allowing them to make zoning ordinance amendments up until the final moment of the board approval. In 2011, the legislature amended that to establish that the zoning in place at the time of the filing of the development application would go to the review and approval of the application. There is an important nuance to that, though, after the fact, and that was brought to light by a court case, Giant Side Brand LLC, correctly. And if there's a zoning change after the application is submitted, that makes the application quote, more conforming, or if it eliminates a variance, that can be applied to the application. Thus, the phase 3 redevelopment plan had made Road D essentially a permitted use.
So even if the meaning of lot was not as set forth in the ordinance or the MLUL, it still would not have required a D variance at the time the application was before.
That is correct, yes.
You may be referring back to this later in your testimony, but is it fair to say that the characterization of the access road, Road D, and its definition as serving these other uses that it was approved in conjunction with, is that akin to a master plan or a statement of municipal intent or understanding if it's included in the plan?
Yes, I believe so. Yes.
Thank you.
And it's also, I think, equally important to note that the phase 3 redevelopment plan, to an extent, was clearly indicative of the council's understanding that this was to be developed as a single unit, which really harkens back to that discussion we just had regarding the definition of lot, both by the township and by the municipal land law. It did show that there was a recognition by the council that individual tax lots were not supposed to function on their own, but they were supposed to function as a development unit or as a unified development parcel. So it recognized that this was a function as a road use, partially defined on the uses that they were to serve. So in my opinion, that goes to demonstrate that they were meant to function together, not necessarily operate on themselves. The third aspect would be the vested rights that were granted with the preliminary final subdivision and preliminary final site plan. So again, not to go into all the dates, but just to read out some of the important ones. On September 5th, 2018, the applicant was granted preliminary and final major subdivision approval and preliminary site plan approval for corporate block 201 lot 1. On August 14th, 2019, the applicant was granted amended preliminary and final site plan approval for the construction of Road D as well as the construction of Road H. On February 5th, 2020, the applicant was granted amended site plan approval to phase the overall project that included Road C. And then finally, February 22nd, 2021, the application for final site plan was deemed complete. So the subdivision approval was granted prior to the site plan approvals. An applicant is protected for 3 years from the grant of preliminary site plan approval from any change that would require a use variance under NJSA 40:55E-45A. And that section quotes that the general terms and conditions that the preliminary approval was granted shall not be changed, including but not limited to use requirements, layout, design standards for streets, curbs, and sidewalks, lot size, yard dimensions, and all track improvements, and in the case of the site plan, any requirement peculiar to site plan approval. So the application for final site plan approval filed on February 22nd, 2021 was within that 3 years of vested right from the time of the last amended preliminary site plan. Thus, there are vested rights inherent with the development of Road D in conjunction with 100, 150, and 200 Metro Boulevard. At no time was it granted the preliminary final subdivision approval for those buildings conditioned on the use variance. At no time was it granted preliminary site plan approval conditioned on the use variance. The terms of the approval are essentially frozen into place. So without those conditions or without a prior declaration from the township that the road may need use variance relief, no such requirement is really being pulled out. And as Merrill had mentioned, this was essentially recognized by the zoning officer who had scheduled this application, not in front of the zoning board, but in front of the planning board. So, under those vested rights, I do not believe that use variance requires required. So in conclusion, if you look at the definition of accessory building or use, as well as the definition of lot, we conclude that this functions as a single development unit. And that's also based on the engineering testimony here tonight. Thus, under that aspect, I don't think use variance is required. If you look at the phase 3 zoning that was in place during the June 24 hearing, we can see that roads were identified as permitted use. Under that aspect, I don't believe that use variance is required. Finally, if you look at the vested rights of preliminary and final major subdivision approval. Under those vested rights, I also don't believe use variance is required.
Use is one of the things that is vested, so the characterization was that it was an accessory use that would be part of what is protected under the vested rights.
Yes.
All right, and now, there was a letter submitted, dated May 17, 2021, from the planning board planner.
May 19th.
I'm sorry, what was the date?
May 19th.
Oh, I have mine dated May 17, 2021.
Oh, do you have more than one letter?
One that I provided to the board that we didn't have last time was the copy I was provided was May 19th. I don't know, I'm assuming there was the same. Well, I think May
I was
19th.
dated May 17.
You knew what he was thinking before he wrote that.
He is very good.
Can we have a
I
picture of the
Can you double check it, see if it's the same one?
Yeah, I guess that's right on here.
We don't have his letter at the font. It had to have been something that they're trying to copy because I want to make sure that there's something.
Almost like.
I'm sorry, what?
No, it's almost like.
It's environmentally sensitive.
I'm trying to.
I, of course, carry around 50 copies, so it's
They're very identical. I mean, each word-
well, we only get it from the municipality, so I can't explain it other than to say that,
I don't know.
this was.
Okay, well, it's
Okay.
the content of the letter, I just want to make sure we're all looking at the same.
If
Yeah,
those
you're
are-
gonna be identical, I'm not sure.
Okay. Okay. Then I would ask, is the,
This is A4.
well, okay, I wasn't sure if we needed it, because I thought the board had it, I don't want to confuse it. but-
Well, we're gonna be talking about it, so I'm sure Mr. Ricky is going to mention it, so let's just mark it.
So, it is the, as I read this letter under the analysis, Mr. Ricky, has indicated that, why don't you read, item B, 2B, and 2C? And then advise if you believe 2C is consistent with your testimony.
So item 2B, page 2 of the memo dated either May 17th or May 19th. Because road D does not provide access to a use located on a lot on which it itself is situated, it does not meet the definition of accessory use that is provided at section 700-3 of the Code of the Township of Nutley. Said definition is as follows, quote, a building or use clearly incidental and subordinate to the principal use or building and located on the same lot with such principal use or building, end quote. Item C, when considering the definition of accessory use that's provided in point 2B above, it is important to consider the following definition of lot, which is provided within the New Jersey Municipal Land Use Law, which supersedes municipal regulation at NJSA 40:55B-4. Quote, a designated parcel, tract, or area of land satisfy a plat or otherwise as permitted by law, used, developed, or built upon as a unit, end quote.
So, as I understand that, and Mr. Ricky goes on to suggest that there are multiple ways to read it. He does indicate that the definition of accessory use and the use of the word lot would be controlled by the municipal land use law, which he characterizes as superseding municipal regulation. Is that correct?
That is how it's discussed, yes.
And is the definition that this is one of the many arguments in support of the position that no due variance is required, is your argument in this regard consistent with Mr. Ricky's analysis of the municipal land use law as being controlling and needing more than a tax lot?
Yeah, certainly when it comes to items you see there, as well as the definition that you provide for the land use law, I believe that if you focus on that definition, you specifically recognize parcel, tract, or area of land, and understand it's developed, built on a unit. I think that provides additional clarity to what the municipal land use law is really trying to establish here. Not necessarily dictating specific tax lots, but looking at the whole of whatever the development is.
And is that one of the two potential interpretations that he provides is at item D2, and is that conclusion, I'm sorry, I'm reading from the letter we talked about before, does the board have to be giving out my version?
No, they have, they have the last meeting,
Okay,
although ours is May 19th.
okay. But for the record, those are the same. So the potential interpretation with regard to D2 is consistent with the analysis that you have provided to the board in terms of the proper interpretation of the ordinance and the municipal land use law and its applicability, its application to the circumstances that are before this evening.
That's correct.
That is what we have on our direct in support of our request for an interpretation, determining that no D variance, no D1 variance is required because the property is in fact, road D is in fact on a lot within the meaning of municipal land use law, and that understanding is confirmed and endorsed by the township's own phase 3 plan, which clearly makes road D, mandates that road D serve these lots. And obviously, the subdivision was in place when that was adopted, so the relationship between these was clear. And finally, the vested rights that attach also provide rights that cannot subsequently be superseded once those rights vest. Those vested rights remain in effect.
Questions from the board? I have a question. Going back to something you said, so the interpretation is that all the lots, all are considered only as one? Is that correct?
Yes, I think it's best identified on the exhibit that the.
Even though there's, the boundaries are there, the interpretation is the lots themselves, 1, 2, 3, 4, 5 lots are considered just one.
Exactly, yes, so,
Okay.
yes.
Got it. Yes.
That would be okay.
Yeah.
I just like an explanation. I'm looking at the planning board resolution from this one was the September 5th, 2018 meeting that was, I guess, memorialized on this 19th of September, that resolution. Okay, and if we turn to page 3, paragraph 7.
Hang on, we're trying to get copies. Sorry, I wanted to have it.
It's part of the applicant's application. They have some planning board resolutions. If you're looking looking at what they submitted. The cover letter is October 15, 2021. And then about 10 pages in, it's a resolution dated, the middle resolution.
I'm sorry, give me a date again, please.
September, the meeting was September 5th, and the resolution looks like it was prepared and memorialized. According to the signature back on February 19, 2018.
September 19th?
Yes.
And this is the subdivision? or
So-
site plan?
This resolution is entitled Preliminary and Final Major Subdivision Approval.
Correct.
Okay, so looking at page 3, paragraph 7, that paragraph states both of the proposed remainder lots are or will be utilized for private roadways within the On3 campus. What's your understanding of private roadway versus what you're asking for here? Private roadways, is it a driveway or is it a throughway available to the public?
My interpretation of private roadway was a roadway that's essentially not physically owned, so this is a privately owned roadway.
And then looking at paragraph 8, it mentions create 3 new tax lots and remainder lot. In parentheses, it says, which will be part of a future application with regard to the private roadway network. So to me, it appears that the roadways were not part of that subdivision preliminary and final. Do you read what I'm reading there? Page 3, the bottom, paragraph 8. In parentheses, which will be part of a future application with regard to the private roadway network. So isn't it fair to say that these roads were not part of the preliminary and final subdivision and site plan approval? They were accepted out, were they not?
No, they were included, which I thought the preliminary the preliminary site plan.
Am I reading the resolution though? Isn't that what it says?
You are, and we testified that there was an amended site plan subsequently that dealt with the roads H and D.
Well, I'm talking, when you're talking about vesting rights, at that point, that was not even part of the application though, is that correct? Or am I incorrect on that? I'm looking for clarification. Because again, on page 4, at the bottom of that paragraph 8 is right before paragraph 9 starts, it says the remainder of lot 1 and block 201 is in the MO zone and will be the subject of a future application for private roadways on 3. Okay, so the roads were not part of the preliminary and final site plan, at least at that point, correct?
You're reading from the subdivision resolution, not the site plan. There was a separate site plan resolution, which is
All right, so I'm reading from this, so during the subdivision, it was not approved. Those roads were not approved and not part of the application as per that resolution.
they were separated from the other lots, and the lots were created. So in that regard, they were part of the subdivision. The design improvements were not part of the original site plan. They were handled through an amendment.
And which resolution talks about those roads?
Then there will be amendment, August 14, 2019.
And which paragraph specifically mentions those roads?
Well, the application says, whereas PB Nutley Master has applied to the planning board for approval of preliminary and final site plan to construct private access roadways identified as road D and H on plans filed with the board as accessory use to portions of lot 201, lot 1 on the current tax map, and it references lot V, W, and X. Those became 101, 102, and 103 when we had originally done the subdivision. We didn't have the lot designation.
Just point me to that language, which resolution?
Oh, it says amended preliminary site plan resolution, and the date on the last page, give me 1 minute. August 14, 2019, they granted the approval and adopted the resolution at the same time.
And, I'm sorry.
Sorry.
And the language that Ms. Gotcha read from is in paragraph 1 of page 1.
I mean, it's the first whereas, it's not a number of paragraphs.
I'm sorry.
No, that's. You want me to give you my copy for the moment?
No, this was which date? I went to.
August 14. August 14, 2019.
So this doesn't reference the phase 3 redevelopment plan that you've been discussing, it only references phase 2.
Phase 2A.
Phase 2A.
That's because phase 3 was not adopted
Right.
until 2020.
So we have to hear about phase 2A. I believe Mr. Ricky is going to give us that history as well. But would you agree, regardless of what was approved, if the planning board had no jurisdiction over something, such as if a use variance should have been discussed and decided, that the planning board never has jurisdiction to decide a use variance, is that correct?
The planning board does not have jurisdiction to decide the end, that's correct.
So if for some reason the planning board approved roads that should have been given a use variance, regardless of what the redevelopment plan, whether that's in dispute or not, but if it's established that at the time that they made an approval, that they actually didn't have jurisdiction, subsequent approvals don't carry through that mistake because they never had jurisdiction to make that decision to begin with, correct?
Question is a little bit above my pay grade. Reason being is, if the planning board if an applicant acts in good faith, planning board, here's an application, deems it complete, here's the application, grants, in the case of the township of Nutley planning board, preliminary approval in which the improvements are all constructed, and then after the fact says, you know what, we never had jurisdiction, to me that raises, again, not speaking as an attorney, but questions of estoppel.
Okay, so it's an estoppel question, and an estoppel can't be granted. You don't have any, you're telling me that you're not here to testify regarding the concept if there was a mistake to begin with where somebody didn't have jurisdiction, whether estoppel applies or not,
I am not going to testify.
you don't have that expertise.
No, but I would want to put on the record that it hasn't been established and there's no reason to think that there was an error made, given the fact that the board's own planner, first of all, the board zoning officer sent it to the board.
And he can make a mistake.
And also the fact that the planner indicated that under the municipal land use law, the definition of lot, which he says supersedes the local, certainly encompasses this. So to suggest that there was an error made years ago, you had the same planner counseling the board at that time, who was counseling the board when we went in for final approval.
And he's going to testify, he's raising his hand, but we're going to hear from
Could you testify to my, how could you testify to my?
We're going to hear.
I read from your letter. I did not testify your letter. We read from the letter.
Who was your planner at the planning board in this case? Who was your planner at the planning board?
Mr. Novak. Well, I were your colleague.
It was definitely somebody from my office.
Well, we're gonna if you just merge this with the lot, you wouldn't need a use variance, you wouldn't even be here. Is that correct? If you merge this road with that lot, we'd avoid this whole issue.
I'm not sure if that can still be done.
It was the applicant's choice to subdivide out and make a separate roadway as a lot, a separate lot, correct?
Of course, it was our application.
What is the difference between a private roadway and a driveway?
I have to take a look at your definitions to, come with something on that. I do have to say it on my laptop. Put it all together.
Well, is there some other standard besides, so you're going just by, I don't even, I have it here.
Your definition limits the access to a single lot, not multiple lots.
I'm looking at the definition section of our code. Driveway is an area of land acceptably serviced, used to provide the vehicular access into or travel within a lot.
Yes. which
Is this
also-
a driveway under that code provision?
It would also depend on how this board interprets a lot. Again, if that includes if that follows any Lane's law definition of a felony unit or a single individual tax lot. If you.
Let's go by our code. If we're gonna use the definition of lot under our code and the definition of driveway under our code, is it a driveway or is it something else under our code?
You need to utilize the definition of the township as lot.
You have.
The definition of driveway is an area of land acceptably served as used to provide vehicular access into or travel within a lot. In turn, the township defines lot as a parcel of land having frontage on a street and occupied or capable of being occupied by a building or buildings, together with the open spaces permanent to such building or building. So if this individual tax lot is not found to meet the definition of lot or so the township's definition, because it's not being occupied or capable of being occupied by a building or buildings, then technically this driveway would not be located on the lot, which kind of brings up the nebulous cloud of what this is. If this is defined as a lot by the township, then it would be a driveway, it would be serving, let me rephrase that. If this specific piece of property is identified as a lot, i.e. its own separate lot, not a development unit with the other lots in consideration, then this driveway, yes, will be serving other uses located on another lot.
I'm not sure. Can you read the definition of driveway again?
An area of land acceptably serviced, used to provide vehicular access into or travel within a lot.
A lot,
A lot.
not multiple lots.
I think that's what the discussion had been, it would be defined as a single lot, which again goes back to whether or not this meets the township's definition of lot. Or if we're considering the municipal land use law definition of lot, which would include a development unit.
But this talks about serving or providing.
Vehicular access into or travel within a lot. It does provide vehicular access, if this was considered its own lot, it certainly does provide vehicular access into it and within it.
So it would be a driveway then.
Could potentially be a driveway, but we classified and received approval for private roadways.
And again.
And the township also characterizes it as a private roadway in the face of the redevelopment plan. It does not call it a driveway, it calls it a private roadway.
Do you know why a separate lot was created for the parcel of land that we're talking about?
Yes, because there are cross-access easements and declarations that are already in place on the property. And the access is provided to multiple lots. All of the private roadways are subject to the declaration and provide cross-access by the other. This is exactly the same circumstance where Ideation Way, which is another one of the private roadways, Metro, they're all private roadways subject to the declaration. 111 Ideation Way is approved. The road, Ideation Way, provides its access. This is the network, and this is what the board has been approving from the outset. There's nothing unique about this.
Does this mean all these other ones are coming back this way too?
Those have all been given final approval.
Okay, good. I don't have any more questions. I don't know what it is.
The roads were given actually final approval.
So this is considered a private road.
This is a private roadway, yes.
What would make the difference if it was considered a public roadway? What would the difference be?
In my opinion, I draw the line of whether or not the municipality would own it. So this is not a roadway that the municipality will own. It's
So the
not something-
municipality doesn't own it, they don't maintain it,
Don't plow it, there's
and it's
a,
only gonna be used inside of that lot or lot.
essentially Road D will be providing access to the rear of the parking garage, which is already constructed on lot 1.01. It also provides access to some off-street at-grade parking spaces there. And it provides emergency access as well around that side of the building.
But it doesn't go up the prison line.
Yes, he does. It goes all the way.
Yeah, it goes, yes, if you,
Well, I'm just going by the blue color on here.
oh, yes,
That's the
that-
municipal boundary.
yeah, so.
Okay,
It
but I
does
said
go
it
to
doesn't
prison.
want the prison way under control.
Oh, I'm sorry, but, right, prison way is above where the color ends.
So it
There was
does,
a road.
all good continue through prison or to or through prison.
It continues, yes, after.
And where's it stop?
I don't have the full plan in front of me. Does it stop?
It stops at a private roadway on the Clifton side called Isabella, which is an east-west road that is already been approved in Clifton.
Right east to west, Isabella, in Clifton,
Is Isabella, is that part private on 3 and the other part is part of Clifton municipality?
Isabella is private on, all of the roads on the On3 campus are private.
Up to Bloomfield Bay.
Yeah, I think Isabella is,
Yeah, next one.
Yes.
I have a question. So this road can be accessed from, if I'm understanding it correctly, once you go in through Kingsland Avenue, you make a left in front of the Ralph Lauren building. You can take this road all the way back to Clifton, or you can get to Quest, you can get to that side road by Bloomfield Avenue. So this particular road is not just access to these two lots, lot 201, 101, and 103. It continues throughout the entire 3 projects.
Absolutely, yeah, so Road D does continue up into Clifton to the rest of the development.
Okay. I just wanted to understand.
No, totally understand. I think it's going to be probably accessing, going north. They would probably stick to that, that's my traffic engineer, but Metro Boulevard would be more direct route that way. So I would envision Road D being more utilized by people who are working at the Ralph Lauren building in the, I was pronouncing it incorrectly, the SI, it's a research pharmaceutical company located at 100 Boulevard.
Is it feasible to say that they would be coming, people from the public would be coming off of Bloomfield Avenue and coming in through this
No.
road? Why wouldn't that be, if it's open?
because it's not open, there are restrictions within the Quest property.
The gate?
There is, people cannot go from this campus through to Quest, and people who come through there's a controlled access, you cannot cut through.
Oh, I'm sorry, I'm not aware of the controlled access. I just went through the whole thing today. I didn't see anything. I didn't know that's something that's coming up.
the point where I was getting to is it comes onto a public road. It's a private road, but it ties into a public. So I was, my point was, no,
I'm not sure what there are a network of private roadways.
I understand the private road is on the campus.
Right.
The lots on the campus, they go through there. But that roadway, when I asked you where it stopped, you said it stops at a Clifton roadway.
It's
I'm
not.
just wondering, the public can come through there. That's what I was trying to get to.
Again, Clifton is not before the board, what's before the board is what this board approved, that's all.
I'm just talking about the road itself. The access from point, the entire road, and that it just doesn't, I just wanted to clarify that what I'm looking at, this road just doesn't end at the end of block 201 lot 1.01. That this road actually can encompass the entire On3 project and can have access, public access from other public streets, not just this little piece.
But I think that those are, the streets you're referring to are private streets. There is no direct access between this and whatever, I don't know what public streets you're speaking about. This road, and we can have the engineer, you can enter on Road H, you go around to Road D, you go into the garage from Road H, and you can come out onto Road D from the garage. That's how it was approved.
That's not right, that's how it was approved, I understand that. I just had a question that has gone into a full circle of, not what I asked, but
Okay, I'm
that's
not,
fine, I will look it up.
there are restrictions, there is not complete open movement from the private Isabella, which is on the campus, to Bloomfield Avenue.
And I asked, what were the restrictions?
Off the top of my head, I can consult with the client, but I did the approval 2 years ago, I don't recall.
Okay, only because, the reason I'm asking is only because I just didn't see them, and I didn't know what I missed, so I just wanted you to clarify what I was missing.
There are key fobs and other restrictions on the property which is owned by, there's restrictions from Quest in terms of access between the On3 campus and Bloomfield Avenue.
And for the record, on August 14, 2019, when the amended preliminary site plan resolution was granted, which mentions Road D and Road H, what was the redevelopment plan that was in place? Phase 3, Phase 2, Phase 2A?
2A.
2A.
Well, one was in effect, but that has nothing to do. One was in effect and 2A was in effect.
Any other questions? Anyone in the audience would like to question this witness? See no.
That's our direct case, subject to our right to recall following any testimony from the board's consultant.
Sure. Mr. Ray. Mr. Ray, when you disagree, for the testimony you're about to give, with the truth, all truth, nothing but the truth.
I did.
Okay, would you give us the name and address?
Yes, Paul Ricky, RICCI, 177 Monmouth Avenue, Atlantic Highlands, New Jersey. Okay. I'm a licensed professional planner, licensed as a street stand. I mean, this board has heard a lot of information. I mean, I don't know what to say.
Give us guidance.
It's difficult to even know where it should begin. But I'm gonna start at the first point. When I prepared my letter, it was identifying issues for really, at that point, it raised issues of jurisdiction. At that point, it went to the planning board, and the planning board attorney provided an opinion. I'm not going to provide any opinions on legal matters like vested rights and the like. I believe it's outside the purview of a planner to opine on legal matters as such. So my letter was written as such. To my knowledge, I just want to touch upon the definition of lot that was touched upon at some length today. That's from the municipal land use law. I'm the one that raised this issue in the first place. To my knowledge, no one else has identified it as a planning issue associated with the application. And I brought this to the townships and the board attorney and the planning board attorneys perspective. I will say with this, in my years as a planner, I have not seen any community ever regulated by that definition of lot under the municipal land use law. When this applicant submitted their subdivision plot and their site plan, all of their lines and how they went about their development were drawn to the individual lot lines.
as part of that development. So their intent was to regulate it on that lot basis. The applicant also indicated that, you know, the private lots or private roadways, which cross access easements through them in the like, and that can be achieved on one lot as well. You don't need a separate, to be clear, you don't need a separate lot for that purpose. The second thing is, there's situations where you can't comprehend that happen, right? When you have multiple, one thing that we have going on here as a tract that the municipal land use law doesn't address, it doesn't address multiple ownership and issues associated with if the correct kind of access, not just access easements, but other types of easements are in place, and someone sells off of a piece, now I don't know, my sewer line or my gas line runs through someone else's property, the things that you can't anticipate at some point, maybe the municipal engineer can and not. But I raised it in my letter because I think it's an issue that had to be at least in some way discussed, rectified as part of this process. But, and I will say, as a planner, I've been licensed since the year 2000. I've never seen it fully regulated as such under the true terms of that definition of a coordinated piece of land as such. You often see on coordinated pieces of land where individuals seek what's referred to as a financial subdivision. The sole purpose of that subdivision, which is likely occurring at some points, is to cut pieces of land for financial purposes, but they seek that subdivision and they're on individual lots. When I came here tonight, I thought that however we got here, and there's probably, you can argue there's some blame to be placed how we got here, right? There's some error that occurred somewhere, right? Likely, is that whether or not Road D is a principal use on their independent lots, right? That's really the question. Whether you have a vested right, whether the planning board granted the site plan approval, whether this happened, whether that happened. Is it a principal use on its own lot? Okay. There's a municipal land use law definition of lot. We heard at length. We heard the township's definition of lot, which I haven't seen in some time. I forgot about that. So look at that tonight. So I looked it up again. While coming here, I have to respectfully disagree with the applicant's position regarding that definition. The township's definition is a parcel of land having frontage on a street, right? It says and. Does this, and it goes on, not or, and. So it has to meet that clause first. A parcel of land having frontage on a street. Okay. It has frontage, I believe, Avenue parcel D has some frontage on Kingwood Street. Road H does not, right? And occupied or capable of being occupied by a building or buildings together with the open space to such buildings or buildings. You cannot build buildings on these lots and have open space. So under the township definition, I respectfully agree, it should not be classified as a lot as intended under this definition. I think the core question is here, right? If you have individual lots that have been subdivided, right? It's a well understood principle in planning and zoning that if you don't have a principal use on a piece of property, you can't have an accessory use, right? You have to have a principal use to have an accessory use. And any way you come to it, what is occurring in terms of the township's definition of accessory use, a building or use clearly incidental and subordinate to the principal use. What is the principal use of Road D or Road H? How is it being used today in its current form? as a private roadway, correct? Block 10, lot 11, which adjoins Road D from Norfolk Southern Railroad, it's on its own lot. How would you characterize that being used? As a railroad lot, or could a building be placed on there? What is the principal use of this lot? It's a railway, right? It's on its own lot, it's a railway. Road D and Road H on their own lots are used for private roadways. And there is a definition that may be more suitable for what it is in the code of the township. I'm taking a lot of those. And just so you know, it's very difficult to speak after someone speaks for 2 hours on the subject. If I can opine as they're speaking, my thoughts are a little clearer as well.
Would it be primary road you're looking for?
Primary road, yes. I got it down if I can find it.
Want me to read it?
Can you read it, please?
Yes, I have it. An internal roadway which provides direct access to a public right of way. That's in the definition section 700-3.
So when the site plan was heard, they excluded these what we'll call private internal roadways as part of the redevelopment plan, and it was in the MO district. At no time was a primary road or any other type of roadway permissible use, okay? But when it really comes down to it, really, the intent, whether it was an ever made or not, it was always the intent of the planning board to regulate these roadways as being associated, maybe accessory was the wrong word used, to be associated with the principal buildings on these lots, right? That was the intent, okay? You heard this government spoke with the, at the time of the subdivision application, there would be a later plan. As I was not the preparer of any of the redevelopment plans, and somehow was afforded the great task of having to somehow deal with issues associated with them and how they move forward. I'll leave it at that. With that said, it was always the intent, to my knowledge, for these roadways to be regulated separately. In the phase 3 plan, I think it's quite clear if you read it, whether that's a valid plan or not, that it was the township's intent to limit the way and control how these roadways are used. It's in the plan. It's clear, it's written in that text. And at the time that the planning board granted the approval, it was meant to tie these parcels to those individual buildings. And any way that it ultimately, we go through this process, that is the goal, that was always the goal of the township, right? It was, the planning board approval was to keep it associated, those roadways associated with the buildings, okay? It's my opinion, if the applicant has somehow found a way to achieve that in a legal manner, that we would not be doing it. That's my opinion. But with all that said, there's no other use of these roadways in their independent sense in the strictest reading of the law. And I raised it as an issue in my letter as this other definition of lot municipal land use law, but it's typically that you take the most conservative approach when you review zoning. I did say in my letter that the municipal land use law supersedes zoning, but as a planner, there are times and there's nuances to anything. There's rules and definitions, right? And to the extent you can alter some way in it's reviewed in municipal land use law, it probably can't. Maybe you can be stricter, but you can't be less strict. There's nuances to everything. So it's always traditionally that towns take the most conservative approach when something's inconsistent with their own code, that it's determined to be used as. And that's what the planning board essentially found, and at least turned to this board for that determination, if that's true, but they would not take jurisdiction over that. Let me look through my notes here. But until I raised that issue of municipal land use law lot, it's my opinion that the applicant oversaw these lots as independent and showed them in their bulk tables and schedules of regulations as separate, and intended to have them regulated, at least from a zoning perspective, separate. Whether this development would operate cohesively, where is the determination made? Okay, the medical school is under one ownership, another property is under another ownership. One's medical, one's going to be office, one's going to be this. Where is the determination made whether something is working together wholly as a true unit in that sense? It becomes difficult to over time and to fully articulate. So again, just to recap, in my letter, and it was discussed at some length, I raised the 2 points, and I brought it to the attention that there was a conflict in the municipal code where, in my opinion, the application did not have a principal use on it that was permissible, and I raised the question as whether the use variance was needed. And at the same time, I raised the issue as whether this application could be reviewed under the definition of lot, under the municipal land use law. I raised that for the planning board to essentially, as from a legal perspective, to provide guidance. I believe he said that there was no jurisdiction on the matter, and now we're at this board. I don't want to be repetitive. From my end, that's how it was reviewed. I'm not an attorney. The amount of information that was provided by Ms. Doncher was comprehensive in terms of everything from the history of the application, when time of application came into play, whether there was vested rights. With all that said, my point was, did the board have jurisdiction at any time because of the issues that were raised? And that's I think the legal determination. Could the board have, were those approvals, are they good? Really? I don't know. I don't have an answer for that. But that's why the letter was written in the manner that it was written, and it raised those issues. So I don't think this board has an easy job. I think a lot of information was presented, but I think the goal always was, and was agreed to by the applicant when they agreed as part of the process for those buildings to be accessory, that roadway to be accessory, whether private or not, to those buildings. The applicant really agreed in theory to, I think, what the township was goals were, whoever we're getting here per se. Right? Am I wrong? And I also wanted to mention the phase 3 plan, right, which was discussed as this being permissible. I think it's important to recognize that plan prohibited uncontrolled access. So to the extent that access is uncontrolled in that phase 3 plan, I'm not sure. It was written in narrative and language. Traditionally, if that's a condition associated with the use of those roadways in that plan, and that's the only thing that I will say is differential. It wasn't carte blanche that those roadways were permissible in that plan. I don't think that was clear based on the testimony. They were prohibited to having controlled access. With that said, I'm sure Ms. Goncher's got 37 questions for you.
Is the questions?
Let's
Does
hear it.
the board have any questions you want to ask?
I don't have any questions. I want to thank you for clearing up some of that. And anybody else have questions for Mr. Ricky? Oh, here. Oh, wait a minute.
I actually do have a question. Can you clarify further? if it's determined as an accessory use, the roadway is forever tied to these lots. If a D variance, if we determine that it is not an accessory use, and a D variance is required, then does this road become an independent entity so that at some point it could be separated from these lots in terms of use?
I think it's, in my opinion, from what I know, if a D variance was required, I think there's the potential to place conditions on a D variance, and where you can require that D variance under the pretense that that these roadways be utilized for those buildings, the same way the planning board tried to do it in its approval, but apparently not effective.
Thank you.
Because for a point of clarity, that's what the concern is here, right? That we could potentially apply the variance, and if we did that, that these two roadways could be, in theory, sold off as independent assets as opposed to the remaining lots that are on this property.
And the question is that I would say to that, if they're already on their own lots, has that already occurred? And without having the condition in place, that's already occurred. That's the question. I'm not sure it's a legal question, but that's the question I would.
Sorry, can you repeat that once more?
Well, if these lots are on their own lots,
Which they are.
which they are, right? And they're not tied to a property, how are they restricted in their use right today? I don't know. I don't see any restriction. I don't know. I'm not sure how it's regulated that way. Your turn.
She's chomping at the bit.
He's dying.
Okay. Mr. Ricky, you referred to a road D and road H, these roads. Do you believe that road D and road H are both before the board tonight with regard to its variance?
I have a little bit of confusion on that, how you're separating, because I think it was tied to the planning board approval of how they can be separated. It wasn't clear to me how.
Road D is part of another lot. It is not a separate lot.
Okay, so it's just, okay, so I stand corrected to that extent.
What is the, do you believe that roads can be zoned? Are roads zoned? Are they in the zoning ordinance or are they roads?
Well, in this context, it's a private piece of property, it's not.
What is
a
their
road.
function?
What?
What's the function?
But it's a private, that roadway can be cut, a private roadway can be blocked off and not given access to the public.
Are you aware that the declaration was submitted as part of this application and every other application which explicitly prohibits that?
I didn't review, but I'm sure it's.
Okay, so that is not something that can happen because there is a declaration of record. It's submitted to this board, it's been submitted to all the applications that we've done. It grants cross-access rights of all of the on-3 campus to those. So the question about whether it could be severed and no longer be available, if I were to take you, you can check it. The declaration has been submitted as part of this record. When you look at it, you referred to, I think, something called the financial subdivision. Isn't the definition under the MLUL what's really applied, that a development that is really approved as a unit? For example, when you have pad sites in a shopping center, you create separate lots and they are.
It's done in multiple ways.
Right, and so you had said you've never seen an MLUL definition applied, but in fact, isn't that really homeowner association, condominiums with their own private roads that may be subdivided? Isn't that one of the scenarios that's likely behind the definition of a development as a unit or a parcel as opposed to?
Yes, and the difference being that you can have a shopping center where there's one lot and from 1 to 50 uses or more with cross access. At the same time, these, what you're referring to as the financial subdivision, the pad sites, those are, as a shopping center, as a unit with multiple lots, as is being reviewed by the township, not a single lot of tract.
Well, and my unit made the statement that in all your years of practice, you've never seen the concept of lot being a parcel developed as a unit. And I'm suggesting that these other scenarios are, there may be lots created for, as you said, financial, which is absolutely correct. And pad sites within a shopping center, and yet these are developments that are actually within the definition of lot under the MLUL, where they are developed as a parcel or as a unit.
I disagree, can I clarify? What Ms. Concha is saying is, I don't disagree with the concept that she's suggesting. Where my point of disagreement is that when we zone and we look at development and subdivisions, that one tract of land that's working together, right, has multiple lots through it, similar to this, but all the setbacks are being drawn, and the town's evaluating each lot independently, okay? So it's not being viewed as a tract of land. By way of example, the setback line for front yard setback, right, there's a front yard setback and it has to go to, it's being drawn to the lot line of road H. It's not being drawn to the perimeter of the tract. So they're not being regulated as one lot in this formation. It just doesn't work. So every town is regulating each lot independently, even that it's one overall shopping center or development under that scenario. Or it can be one lot with all cross access going through it. But once you cut it up into multiple lots, you're regulating your setbacks and your regulations to those lot lots. Otherwise, they would have condoed the application and they could have done that. They could have got a condo association. They could consolidate road D into the other lots. They could have done it different ways that this roadway wouldn't have been on a principal, would have been on its own lot. And if you ask me if this roadway was where they were attached to the lot, would it be accessory to that? Yes, it would. Clearly. If they were combined, it would clearly be accessory to that building. Because it's on the same lot and it's a roadway providing access to it. That's really what we're talking about here in a nutshell.
Let me ask you, you made the comment about what the intent of the planning board was. The planning board granted preliminary and final subdivision at the same time they granted preliminary site plan. So there's no question that they weren't aware of the subdivision and that how the roads would be in relation to the lots. Is that correct? The individual building lots.
It's my understanding.
So that's a simple question. Was the subdivision preliminary and final granted at the same time the preliminary site plan was granted, so that the planning board had before it all of the information with regard to where the lots would be in relation to each of them?
Yeah, that's accurate.
And does every road serve buildings and uses? Is it the purpose of a road? It provides access to, that a road does?
Generally speaking, yes, but we have private and public, but yes, the roadway provides access.
And if, as I indicated, if my representation, obviously can be checked because it's part of your record, that the declaration assures access to the buildings, including these and other parcels, does that address then your concern that that could be sold off and that the access rights could be terminated?
In this context.
And then you also made certain statements with regard to the different uses on the site. Are you aware that PD Nutcliff, med-related entity, is the owner of the med school, and that's the ground lease, that it's owned by a related entity?
I remember.
And are you also, are you aware that, Ideation Way is also a private road that was granted preliminary and final site plan approval? And I think there's Medicine Way, and that those are, also, we're treated separately, subject to the declaration, from 111 Ideation and other lots that were, in other words, this was the intent and the plan of the overall development. And were recognized through the redevelopment and the approvals that were granted. Are you aware of that?
I can't speak to all the specifics.
Okay, if I were to tell you that Ideation Way is the equivalent of Road D, and that it's a private roadway in the development and it, was granted preliminary and final site plan, are you?
I can't speak to that application, could be your next, I can't speak. I don't know.
Were you the planning board attorney? I don't know.
I'm not sure.
The planning board, see, I'm not sure I was gonna say
Mr. Novak.
elevated you, but I'm just saying it may not be an elevation for planning, I take that back. Were you the planning board planner at the time of either the med school application or the 111 Ideation?
I will.
Okay, and this issue did not come up at that time,
That's my notes, yeah.
so you didn't raise that, there wasn't a D issue back then when the same circumstances came with.
I don't recall the particular fact, but it was not raised.
Okay, there are no public roads there, and there are separate road lots that were granted approvals in connection with other site plans on the site, so.
I'm saying, you may be correct, Ms. Patrick, I don't recall it.
Okay. All right, so, I want to make sure I understand this. The roads were granted approval, so therefore the private roadways were granted site plan approval, so therefore, since they've been approved under the MLUL, they are streets or roads within the definition because they have now been granted approval by a plan, correct?
I don't know that it's a legal determination. Does a private roadway become a roadway because it was granted by the planning board? I can't answer, because you said you gave access to it in this context, that's a more general question. Like my understanding is Princeton University has private roadways that they close once a year to retain control of that roadway, so it's not a public roadway. So there's what I'm saying is that when you ask it in general format like that, there's nuances there.
Well, for purposes of section 35, if it's an approved street, is it a street?
If you grant a planning variance, you're suggesting, is your question, if a planning variance is granted for a private roadway without public access, does it become a public roadway?
Yeah.
What is your, I don't understand the question.
If the road has been approved on a plat, do you need a planning variance under section 35? Or is a street, once it's approved? it's
No, I believe
recognized?
you're correct. If it's approved on a plat by the board, then it's considered to happen.
Um,
You assume that in with section 35. You assume that in with section 35.
I need to be what section. Okay. So let me just go back, are you suggesting now that the MLUL, which says that a lot is a parcel of land that's developed as a unit, is not the appropriate definition of a lot in Nutley?
I'm saying that although it's written in that terminology that I re-identified in my letter that raised it as an issue, I just said tonight, as a planner, and I'll try to go through the example again if it's appropriate. I've never seen a community absorb or consider a tract of land that's as such and regulated from a zoning perspective as one piece of property. because setback lines will be running through internal roadways, buildings, and the like, trying to reach the perimeter of the track. Because if it's a lot, right? There's a term of art called tract of land and a lot, right? A tract of land is commonly referred to as multiple properties that you know, whether it's defined or not, as professionals, we would call a tract of land would be in a context, multiple lots in the same fashion under common ownership operating as one unit, okay? I wish the municipal land use law definition referred to it as a tract and not lot, because all I can say is that I testified in this contract in over 200 communities, right? And there were multiple applications similar to having development applications on properties. If you want, I can go through ones that I went to most recently in Evesham, maybe a year or so ago. We were asked to provide like 25 variances for the same thing because
I'm assuming
the
it's not
buildings were
just,
going over
but
individual lot
you
lines.
don't know
Yes,
that.
yes.
Let's just clarify, have you read the phase 2A redevelopment plan?
Not tonight.
Okay, so you're making statements. My question is, this property is all part of one redevelopment plan area, correct?
Well, that's because the phase 3 is no longer, I'm not sure.
The buildings here are part of the phase, the buildings,
The buildings are into it.
correct. And that is a parcel or tract of land, and this road was provided as access to that.
It's an
By
area.
approvals granted. Is there any question in your mind that that road was approved to provide access to the buildings there, particularly since the driveway
No,
goes directly to?
as an accessory, in an accessory manner.
Well, the subdivision was granted prior to the site plan for the road, so clearly they knew there had already been a site plan.
When you say this road, you mean H?
No, H is not an issue, D is the only one that's before you.
I thought you were pointing to the ground.
Oh, no, I'm sorry, I just was pointing generally to the exhibit.
Can you repeat the question?
Sure, subdivision approval was granted first. The roads were approved after subdivision approval was granted, and yet the roads provided access to the garage. Is there any question that the board knew at the time they granted the approval that the road was for the purpose of providing access to those properties as a unit?
My understanding was it was always known by the board that they were going to provide access to the unit, but the redevelopment process was always behind how those roadways were going to be fully utilized. That's my understanding. And that's why you saw it in the subdivision application, and it was always the desire, I'm not the township planner, it was always a desire to regulate the roadways in a different fashion for whatever reason. Okay, there always was.
And yet the approval was granted by the board, which is involved in the redevelopment process.
Yes.
I wasn't clear from your testimony. Is road D, does it qualify under the definition of lot under the municipal, under the Nutley ordinance? Can it support a building?
No,
And yet a lot in the town must be able to do that by definition. Capable or,
it says,
actually, I think that's.
parcel of land having frontage on the street, road H doesn't, we're saying road D, right, you're saying road D? Well, road D has access to the street,
Can it support a building?
it's- Let me retract that statement, we could support a building in the lower portion of it.
And meet the criteria of the ordinance, is that
And
what?
then there's other elements associated with it. Let's go through it after this. Except for subdivisions approved after 1979, where those lots or parcels which conform to the Nutley schedule of regulations as the bulk height and other requirements. Do they? I don't know the answer to that. All parcels that are situated in the same residential zone.
This is in the 2A redevelopment area. It doesn't mean it doesn't come within any. the zoning criteria.
So you want to use half the definition?
This is the question, you're saying residential, and I was saying it's not in a residential zone. You referenced the residential zone.
Well, that's what it's saying, the definition. It goes on to say, all parcels that are situated in the same residential zone or contiguous in common ownership and containing only one principal conforming use shall be considered as merged into one lot for the purposes of this chapter, notwithstanding anything to the contrary with the tax map or elsewhere.
So in other words, that's another area under the municipal land use, under the Nutley ordinance, where lot is not a tax lot. But depending on its the language you just read, they would be merged. So you would have multiple lots, which would then be viewed as a unit because they are not. They are merging tax lots.
I think it has that potential. I have not reviewed every single
Well,
one.
I'm just saying that there are, so right within the ordinance, there's recognition that there are parcels which are not coextensive with a tax lot, and they are also a lot. Those have to be residential, this is not, I'm not suggesting that. But that coincides more closely with the definition, as I understand.
There are similarities.
I don't know if that, that's all I have, cross examination, on a summation of any kind.
I have.
I assume not for me, so
Not for you.
for you.
In your analysis, your letter, you gave two options. Options. Two. I'm sorry, options 1 and 2. Which do you think is more correct?
When I prepared the letter, and we just discussed municipal definition of lot, which is, a paragraph long per se. I mean, that may have to be further evaluated, to the extent needed. But with that said, when I prepared the letter, it's well understood, when you have a parcel of land, and that's what stems from the definition of accessory use, that you have to have a principal use on a lot to have accessory use. And I continue to go back to my initial point, is that the principal use of a lot is a road. Wherever you get there as a planner, some of these nuances need to be looked at in terms of the municipal definition of lot. But as a planner, throughout 20 years that I practiced as a planner, that each lot has to have its principal use before it has accessory use. And that's where my letter said. At the same time, I raised again the issue of the municipal land use law definition of lot, which I haven't really seen ever before. But I tried to be fair in my review of the issue, and I brought it up for legal interpretation. But what I believe is when it's determined that you have a lot, it has to have a principal use first, and then you can have an accessory. If at some point, the town would probably even look at precedents and how it's looked at the issue over time. That's how it's essentially done everywhere. And that might be an issue that needs to be looked at, the precedent set on that issue.
So, if Rosie were to be determined as an accessory use attached to these lots, currently there are structures on there. If at some point in the future, the site was modified and the current structures were either demolished or modified in such a way, could those structures be then extended onto the roadway because it is an accessory use?
No, I'm not really visualizing your question, sorry.
So in other words, let's take the parking lot. On lot 901. If it were to be determined at a certain point that the parking garage, I'm sorry, if the parking garage needed to be extended in size, if Road D was currently, if this board determined Road D to be an accessory use, could that parking garage, given whatever setbacks are involved, could that be extended into the roadway?
Well, the lot 1.01 has been, in terms of its setbacks, has been regulated independently of road. How it's been applied, the planning board. I'm not sure how later on they can now say, we're going to, I don't know the answer. I guess in theory, there's a possibility that it could. I don't really have an answer because there's no real definition of lot. Because anything's a lot, anything can happen. So how do I regulate? I would have regulated it as a planner that if there's a lot line, that they would have to meet the setback from the lot line. However, if these lots are now in common ownership, and you take the definition of lot that, it's all one lot and they're in common ownership, then someone could.
They're not common ownership. Well, there might be common ownership, but they're not, they're keeping them separate. So, Patricia, are you hearing what he's saying is that you have to build within setbacks.
That's how it's been regulated. And that's what I was pointing out, that was a distinction. If this is just all one lot, where do you draw the setbacks? How do you regulate? Irrespective of the fact that there's individual lines going through it that say they're lots. As a planner, if this is one lot, that was my point. How do I, the planner, review the application? And I'm drawing lot lines through other buildings to say, what's the setback? What's the front yard setback? I don't know. And that's why in every town I've ever got to, is that they review these as independent lots from a zoning perspective. Because how else would you draw a front yard setback in certain situations? It would go through a roadway. It could go through another building. And the setback is an unobstructed line, right? Can't be anything in front of it. In another community, there was a private roadway running through a lot, right? I required the setback line to be drawn to the roadway and not to the property line as it was, because how else would you regulate it? Because it has to be a setback, it has to be unobstructed under pretty much every definition of setback. If it's not unobstructed, it doesn't need a setback requirement. Does that make any sense? I'm trying to explain that. I'm confused now because if you find something to be one lot, how is it regulated? Considering it has lines running through, right? It's not just one. It's not one parcel without lot lines running through.
So, am I correct that the board has to decide whether the definition of lot is through municipal definition or the MLUL definition? Because that makes a difference under what our definition of accessory use is. That
the best way for the board to look at this? Board is looking to you for
I
guidance.
think the main question is whether or not road D is a principal use of the road.
So meaning is road D use just as a road? And that there's nothing else on road D that creates the definition of accessory use?
And then it's like, if you come to, if it's the principal, if road D as a roadway is the principal use, how can the issue that came up was, how can it be not permitted in accessory to the building? That was the issue, right? If it's a principal use and it's not permitted in the MO zone, right? How can it be accessory to the building? That was the issue that I had. Right, cool.
Yes. She needs break.
Okay, let's take it, then break.
She needs. Ready.
Sorry, I just realized that.
I actually said that
Oh,
20 minutes ago.
Yeah,
I wrote a
we're done
note
with
to
this
say,
one, take a break.
thank you for a break.
so are we on break?
Yes.
Ready?
I'm ready. Okay. You want to summarize or?
Yes, we believe that, as we have placed in the record, that, the, road D, is accessory, it provides access, to the buildings, 100, 150, and 200. It's currently being used in that manner. 100 is occupied, the parking deck is being used. The 200 Metro will also use that deck. However, the questions that were raised tonight seem to go beyond the application that was made. The application, remember, was filed back in February. Road D, the town is fully aware that Road D was going to be on a separate parcel. But the entirety of 100, 150, and 200, along with Road D and Road H, which is located on the same lot as the garage, 150 Metro, all function in unity. They, the people in the building park in the deck exits, enters and exits from Road H and also exit onto Road D. It is clearly and was always contemplated to operate as a unified parcel. There is nothing in the municipality's language in their definition which says tax lot. There is nothing in the MLUL that says tax lot. That is sort of read in, and while I appreciate Mr. Ricky's experience, I think we have identified ways in which the interpretation applies to other circumstances that exist in shopping centers, in homeowner association projects where you have roads, which are private roads and are viewed as accessory, although they are on separate lots, and that is exactly what the MLUL contemplates, where development is done on a parcel basis, not on a tax lot basis. Furthermore, your own definition, it's not clear that the contemplation is that the fact that it was subdivided as a separate parcel, not clear that this comes within the definition of lot, and your ordinance also can be read, as Mr. Ricky read into the record as part of the definition, that a lot under that definition is also defined as a parcel which comprises multiple lots that are viewed as being merged together. A road is by its nature accessory. It provides access. It is defined in section 7 of the statute. It defines what a roadway, public or private, is, and by its nature, it provides access to other parcels, and it is accessory to them. What I seem to be hearing here is a broader inquiry. There's no way that ASI is going to occupy a building where it appears that people are talking about their right to access the garage. Clearly, there is a site plan approval in place. It provides rights, whether it's appropriate for a planner to discuss it or not. Clearly, those are provisions of the municipal land use law, which the planners interpret and apply on a daily basis. And the rights that were granted, we believe were properly granted when they provide the right to use Road D to access that garage. But clearly, the 1,200 employees in the pharmaceutical company who are under lease to building 200 or going to 200 Metro are not going to be willing to take occupancy of a building where there seems to be questioning of whether they have a right to access to parking garage. And frankly, we think there is no basis for that under the clear intent of the township that Road D was to provide access to these other buildings as a unified whole by virtue of the Phase 3 plan, which recognized whatever qualifications may have been applied, there is no question. And those qualifications were the thing that got that plan thrown out, not the fact that Road D was to provide access to the properties within the Phase 2A redevelopment plan area. So clearly, the municipality saw those roads as being accessory, providing access to these buildings. The vested rights protect our right to use them. And finally, the municipal land use law definition. I don't, with due respect, think that the standard is whether the board's planner has seen this in action. Although I think he acknowledged that he has seen the definition under the MLUL, which contemplates a parcel that is being developed as a unit. And I think the issues that were raised with regard to where you would draw lines, clearly that's not an issue here because the buildings are have been built. The other buildings within this development parcel were existing buildings. There was no problem with lines running across the parcel or some of the other family issues that were raised. Those are clearly not relevant in this circumstance. And I think that the alternative that was provided, the superseding definition of lot within the MLUL, clearly means that Road D is accessory to other uses and buildings on the same unified parcel being developed as a whole. All these other issues may be interesting, but I don't think they go beyond the definitional language of the statute, which I believe is controlling. Your own planner acknowledged it supersedes your definition. And frankly, I don't think your definition is to the contrary. I don't believe that this parcel of land qualifies as a lot as defined in your municipal ordinance. And therefore, I think that it's appropriate that it be viewed as accessory to the other buildings which it clearly serves. And that the interpretation be that no D variance is necessary so that we can move forward as contemplated approvals previously granted. Occupancy, the building can be occupied, the parking deck can continue to be used with access onto Road D as it has for the other occupants at 100 Metro. And we would ask that the board make that finding that no such variance is required. We also would like to renew our request that since this has been pending since February, that the board hear the use variance application this evening so that we can get a determination and move forward, hopefully through the interpretation, but otherwise the use variance, because we are unable to move those tenants into the building. It's unlikely that the tenant would be willing to occupy when the question of whether or not they have appropriate access to the parking garage, which is part of their lease, has not yet been resolved. If the board is not prepared to hear the use variance tonight, we would ask for a special hearing between now and the end of the year so that we can move forward, because we're going on 10 months trying to get this resolved. And we have moved with dispatch, knowing that we have a tenant that we need to move into that building and that there are 1,200 jobs at issue here. So we would ask the board's consideration. We don't believe we need a use variance. If the board differs, that they hear the use variance, and alternatively that they provide a special meeting so that this can be resolved finally. Thank you.
Excuse me, would you consider consent to a partial use variance to allow tenants in building 200 to use Road D and come back for consideration of full variance?
If you mean if the board determines
You mean that they haven't already made up their mind?
I don't know what anybody on this side's thinking or this side's thinking.
And what if it turns out differently later? Do we throw them out?
Well, no, no, I guess you have to go through the interpretation issue and then we'll.
But I guess what I'm saying is that when you say a partial, I'm not sure I understand the partial variance, what that means.
Well, you know what, I don't know what the board's gonna do on the interpretation, but assume that for one thought, because when you're talking about a special meeting and you want it to continue, and we have people that are waiting, also.
We're not unmindful of that.
I understand
We
that.
filed in February with the other board. We're not.
With the other board, not with this
We
board.
understand. We're
Okay.
saying from the perspective,
So, but
we filed this one in August.
one solution may be, because when you mentioned tenants, that, if the interpretation is such that a use variance is required, if the board would consider tonight voting on a use variance with the condition that it's limited to just the tenants in the 200 building, that use would be an accessory use for that building, for those tenants in that building.
I would speak to the client, I mean, while you're delivering, we'll speak to them, I'm trying to figure out how that works, but
I don't know
appreciate
either.
your- I
I
appreciate the creativity, I'm not being critical, I'm just saying I need to figure out what that means practically.
I'm trying to anticipate something where, rather than have a special meeting or hold up, I think that the town and everybody in the town would love the buildings filled with tenants. It's tax money, it's good. But however we can accommodate that within the system here, if we can. I don't know.
We appreciate it, that's why I'm not rejecting, I'm just saying, I need to think it through and see.
Yeah, I mean, it's one of the challenges that that's not the only use or something, parking garage. So it's-
Well, that's what the issue would be, is that the accessory use condition would be considered as use for the tenants of that building, and then come back for a more open discussion.
The only other
That's
legal
just
use-
hypothetical, state it came back and then didn't get it, so now we do that.
How do you regulate it?
Okay.
Let me say this,
Just
by the redevelopment plan, the 2A redevelopment plan, the only users, now I have to go back, but I don't have it in front of me. 100 and 200 Metro are the users of 150 Metro, which is the garage, the deck. The board amended the plan temporarily, the town amended it to allow the med school students to use the garage temporarily while their deck was being constructed. That was the only, there are limitations on who can use it by virtue of the redevelopment plan, which of course is the zoning ordinance for that parcel, for that redevelopment area. 100 Metro is fully occupied and has been using it.
See, I'm only talking about 200 because you're talking about holding up potential tenants there, and that's what my suggestion is, if we can work something like that out, if need be.
Okay. I guess my question is
I
that
don't
the
know.
people in 100 are using it, they have their CFO, they've been using it, they have final approvals, and this was not an issue, so.
Well, you raised the concern about building 200, and that's.
And I appreciate it, that's why I'm saying we just need to think through what the consequence of that is, because after they move in, I think they would need to know that it's not gonna go away, once they make that investment. So, I appreciate it, I'm not being critical, I appreciate the attempt to find a way, just need to think it through, that's all.
How do you interpret it?
Well, let's get to the issue at hand.
First of all, is anybody in the audience want to hear regarding this application before we go to the vote?
Mr. Chairman, I have a question.
Go ahead.
There's been a lot of information that was brought up tonight, lots and uses and ton of other things. Can you please clarify exactly what the board is going to be voting on tonight with this application?
You're asking me?
Yes.
Okay, so the board is being asked to determine, I can't see you, so.
Yeah, I'm sorry.
Okay.
I want to test
The board is being asked to interpret whether road D does not meet the definition of accessory use, whether it meets the definition or not. And if it does not meet the definition of accessory use under the code, you've heard the explanation, meaning, is it
Right, I just wanted to clarify exactly.
Is it an accessory use under our code or not? If it's not an accessory use because it's a separate lot with a separate use as was described. If you look at Mr. Ricky's analysis, under the definition in the town ordinance, then your interpretation is that this requires a use variance. If you find that Road D, although not located on the same tax lot, it is an accessory use because the definition of the lot under the Municipal Land Use Act, which says that a designated parcel, tract, or area of land established by plat or otherwise as permitted by law and to be used, developed, or built upon as a unit. So this information is contained within Mr. Ricky's report. And then recalling the testimony of the applicant's planner and engineer, without respect to vested rights, this board is not deciding what's a vested right or what's not. You're just being asked to interpret the code. And Mr. Ricky's description of that, and I believe at one point Mr. Ricky said in his experience, and correct me if I'm wrong, Mr. Ricky, most of the time municipalities go with their own municipal ordinance, but this is a different situation in terms of the definitions, where there's a bit more openness in the municipal land use definition. Is that correct?
Well, in the definition too, it says as permitted by law, you said, right?
Okay, so that leaves open.
At one point, you know, all these buildings weren't all there, right? The parking garage was constructed, right? So there's one lot, the side yard setback runs through existing buildings, right? So would have a side yard setback variance need to have been granted in that zone? So my point is that I've never seen it unilaterally, that miscellaneous law definition of lot applied. I personally testified in a situation where I think maybe 30 variances required in a similar scenario where they were, as described to Ms. Gonchar, where there was multiple properties on as part of a larger development.
So what's this, the board is trying to determine your interpretation as to whether Road D is an accessory building or use or not. And which definition you feel most comfortable using, and whether one limits you to one thing or another.
Okay.
Thank you.
All right, there's no more discussion or any more questions. I'll look for a motion.
Mr. Chairman, I have a motion to disapprove as requested to the applicant, PB Nutley Master LLC, Road D as an accessory use to lot 2, 201 lots, 101, 102, 103, which includes the buildings and properties known as 100, 150, 200 Metro Boulevard, and is not permitted as proposed, and will require a D variance.
Do we have a second?
Second.
Okay, I'll ask the secretary to call the board, please.
Ms. Dougherty,
Yes.
Ms. Castro,
Yes.
Mr. Scheidel,
Yes.
Mr. Daniel Tolby,
Yes.
Ms. Wallace,
Yes.
Mr. Battaglia,
No.
Mr. Graziano.
Hold that, please. Okay, so
Mr. Graziano,
I voted yes.
I'm missing something.
The interpretation of the Road D does not meet the definition of accessory use.
So it will need a use variance.
We need to schedule use variance. I'm not going to move the use variance this evening.
sorry, excuse me.
Yeah.
Yes, council. Would it only be 200 if you were looking at some kind of temporary, or is it, I forget how you characterize it?
You can testify, but you advise the board that it's just building 200.
Yeah, I have the address. That's the one that you're trying to move in.
That everybody else is already in those other buildings and using the
But you're
road.
now saying that with this interpretation that you are subject to a use variance to use the road, and the people who are already in the building are now in jeopardy.
Right.
Well, I don't know whether at this point in the night that we can fashion out something that creative if it's going to become too complicated. So right now it's complicated. If we
You've got to memorialize it.
So, well, the board can do anything, in terms of reasonableness that
This is a
they
separate-
want, but it's a separate issue and it sounds like it's becoming more, my suggestion was an easy suggestion, so I don't think we can accommodate that tonight. I think that well, I mean, you can take brief testimony that was in terms of particularly suited and, benefits, you've got a planner here. And you can move along because the road's already built, so you don't need any engineering testimony in terms of. all right,
So we're looking to let them continue to use it and to use it as an accessory road
until a more formal hearing can take place, but they were worried about that that's going to be yanked out from under them. So the suggestion was, and I based that suggestion on their indication that those other tenants were already in using the road, that you don't want to foreclose, you don't want to prevent you perhaps from creating something where you lose a tenant if we can do something creative with tonight.
Well, I have no objection to that.
Do you want to go to the next two applications and then come back to them?
Wait till.
Now, the first time we waited to other hearings. Why don't we do that for
See if
now?
there's something.
Yeah, you can maybe put some together and give you Mr. Ricky a little time to think of any.
Gentlemen, on your other applications, and I hate to oppose, but I would be more than happy to compensate each of you $1,000 tonight to reschedule or get a continuance so you can carry on behind us, and we'd be happy to pay.
Who are you?
I'm Eugene Diaz, Prison Capital Partners, PD Nutley, the owner and the client in the application before you, which you so just erroneously, you just invalidated the certificate of occupancy for Ralph Lorenzo building.
I just
All
did is made a ruling on
yeah, I thought it was right there. I thought,
so we're gonna
we're going
move on now. We're gonna move on now to our other.
All right.
I've made an offer, maybe perhaps they'd like to consider it. It would help your night, it would speed things up, wouldn't it?
Ours is 5 minutes. I
It's
think.
10:30, and we don't,
It's 10:30.
we'll just go to the other.
That's what it is. We're gonna go on to the next one, which is 11 Center Street.
Do you want us to move this, is this interfering or see?
Maybe for this gentleman, to buy. Secretary, two people are,
Regarding addition to zoning board approval, 111 East Center Street, lot 9604 /3. Dear Mr. Mockler, your request for a permit update at the above referenced premises to construct a full basement and a separate entryway to the basement, which was not previously approved by the Board of Adjustment. Application ZBA 20-0051 as shown on the plan prepared by architect Roy Emerald dated August 25th, 2021, is denied for the following reason. This property is located in the E-4 district as shown on the Nutley zoning map. Chapter 700, Article 16, Section 700-113A of the Code of Nutley states, no conforming use nor structure nor lawful use on a non-conforming lot shall be enlarged, extended, reconstructed, or structurally altered, except that such structure or use may be structurally altered to correct an unsafe condition. A non-conforming structure or lawful structure on a non-conforming lot may be restored or repaired in the event of partial destruction thereof.
There's no phone work, just speak.
Oh, okay.
Try to speak as loud as you can. This,
You're good.
this thing is good, okay. Are you all over for your testimony tonight?
Yes.
All right, we need you all to be sworn in first, so. Swear the testimony about the truth, the whole truth, and nothing but the truth. Okay, now we need you to give your full name, spell your last name, and give your address.
Okay, start. My name is Rui, R-U-I, last name A-M-A-R-A-L. I'm a registered first. Now been in front of this board a few times. Francisco Mata, F-R-A-C-I-S-C-O. Mafla, M-A-F-L-A.
The address?
111 East Center Street.
Sir,
Darwin Rubio, last name R-U-B-I-O, 111 East Center Street.
okay. Who would you like to tell the board? Who wants to start?
I should probably talk.
Yeah.
Basically, we were here last year, in front of this board, so in addition to this existing two-family house on East Center. The problem with this house was that, it's a two-family, but the zone is a B4, so it's a commercial zone. So we got approvals to basically extend the house, even that we did an addition to the rear. However, the basement, our intention back then was to build the addition with a crawl space. When we started building this house during the summer, you kind of realize, well, we could work on a few extra feet. The contractor gave them a decent price. Hey, I could have a basement instead of just a crawl space. My client, he does a lot of landscaping in the back, he grows vegetables, he has a patio that takes place in the backyard. So I figured, well, if we build a basement, that would be a great thing just to store backyard stuff. So then he proceeded, he asked me to do, well, so that we don't get issues with the city. I even recommended let's send plans to the city, make sure that the basement is okay, so they do the inspections and footings. And then he wanted the rear access out, so we had to build a masonry staircase behind the house. That would basically access the basement to the rear yard. Well, the basement is okay to build, it's not an issue. However, the staircases, the zoning officer was saying, well, it was not approved like that in the beginning. Now you're doing an access to the rear. It's not, and since this is a commercial zone, it's a complicated thing. We're not going to approve. We have to send you to the board if you want to build that staircase in the rear of the house. I have a picture. I don't know if we can. But as it was building already, so it's built, but it can be covered. So it's high or whatever. It's not an issue. But that's when when he went for the inspections, in fact, that's what he knows, well, we should send it to the board, so don't go too far, and then don't finish it. Let's get the approval, and then come to it, go build it. So basically, we're here to pick up approvals for that staircase that goes to the backyard to the basement. It doesn't really affect much. Originally, we proposed to do a staircase that would come from the second floor to the backyard. And that staircase extended way past this basement access. So as is, this doesn't go any farther than what was before in regards to staircases. Well, that's.
Will the staircase still be there?
Well, we have modified the staircase now. Originally, the staircase went out and then turned back in,
Which was going to take a lot more space.
in the backyard. So we modified the drawings to basically have a staircase that would come along the side of the house. Rather than coming out this way, it would go down along the side of the house. But that's still not an issue. The problem is the access to the basement.
Yeah, initially, it was approved for a phone, but then I realized it wasn't going to be enough for me to use as a storage because it wasn't going to be enough space. So, for my grandkids to have a place to live in the backyard, we needed an additional little more space. So therefore, I decided to make the basement, full basement for storage. Go to the staircase, going with access to the basement to make it easy for us to put the stuff in the basement. Students, and my grandkids toys, which
I'm looking at the drawings here of your basement. You've got it split up into a bunch of different rooms. What's the purpose of that?
Well, again, as I say, the last time, family is growing and we need more space for my grandkids. They need additional rooms, and also for us, we only have one bedroom. I was going to keep 2 bedrooms and the dining room.
Wait, I'm sorry, you said there's rooms to the basement? There's an existing basement.
There is a part of basement.
Yeah, the basement plan. Look at the basement.
It's an existing basement.
Which is.
Broke it up into different rooms. It shows rooms in here.
Well, there's a bathroom, there's a laundry room, there's basically like a kitchenette, it's downstairs.
It's an apartment, it
It
sounds
looks like
like.
an apartment to me.
Well, it's not, it's for our own use, it's what they use. Basically, they use the basement as like they've almost made their main living room. It's not a separate apartment.
There is a separate apartment if you have a separate entrance to it.
But it doesn't have a kitchen, it doesn't have stove, it doesn't have anything, it just has a house.
You just said kitchen.
No,
It's the kitchenette.
It's like kitchenette on the existing basement.
it's not like, I mean, again, there's no stove, there's no nothing, it's just, I mean, they use it for like prep foods, that's what she does.
See, the
but it's
problem
not
the town has is that when you create a separate entrance into a basement that's set up with plumbing and a kitchenette or an area, like, it's very easy for someone to create, and I'm not saying you would do it, but the next owner or anybody else coming along, as soon as you have those 3 components, where you have plumbing, a separate entrance, and windows and other things that are available down there to create an apartment, the town can't enforce what's going in there. And it's that separate entrance that creates the problem.
Well, the house already has a separate entrance.
Directly into the basement,
Correct, on the side.
doesn't have a full bathroom.
No, it's, well, the bathroom has, it's an existing bathroom. It's been there for many
You've
years.
got downstairs, and I'm looking at the existing basement. There's a room with closets on the left side.
Correct.
There's another room that's just a large room, and then another small room in the back.
Yeah, this was the one in the middle, this was a mechanical.
Mechanical.
Now we're basically removing all of the mechanicals from here, putting it into the corner so they can have access to the back, to the back storage.
Where will the entrance there?
However, this, the main floor was originally the house was in the two bedrooms. And they don't use the upstairs. In other words, they don't use the second, the first floor, because there's one bed.
They use the second and first floor.
Yeah, because this, one, the top, they just, given his life, we're going to want this, apartment on the ground, on the first floor. So they don't need a number of bedrooms. So that's why they use the basement, that's their main living space. Upstairs is one bedroom.
You have 4 bathrooms in this house right now? The way I'm looking at it, I see one in the basement, which has a tub, a toilet, and a sink. On the first floor, you have a full bath, one shower, and a half bath.
The half bath is not there.
And then it's not there anymore?
No.
It says existing. Okay, then on the second floor, you have another full bath and a bath with a shower. 2 bathrooms up there, right?
Which is gonna be for the,
I'm just saying, they're there.
For the tenant?
So that's a lot of bathrooms in a 2-family house. But, you know, people like, take a look at that. And then you have 6 bedrooms.
it's going to be, hybrid.
There are 6 bedrooms on these.
The bedroom that is there now is going, it used to be the dining room, so it's going back to be a dining room. Basically, and as I said, the addition that we did was that 2 bedrooms on the first floor and 1 master bedroom with master bath on the second floor and living room. That was the addition. So we had the bedrooms and the bath were added. Those were the additions.
Okay, and what kind of space would you say? Just 4 bathrooms, 4.5. And that's a 2 bathroom.
The half bathroom in the first floor, we're actually making arrangements, but it's not.
Well, it's on the drawing. This is the drawings you gave us.
Something.
And I'm all about the drawings you gave us.
There's something like this. Half bathroom in the first floor is longer, yeah.
But now we're going to have a 2 bathrooms.
This is zoned for a 2-bedroom, a 2-family house. If we were to add a entrance, as you're proposing, this property is in essence a 3-family house. And it is extraordinarily difficult in our town to add density like this. There's a reason why. This is a challenge. So I understand what you're gonna use it for. You completely respect that. The family's getting bigger and all that. But the problem is what happens when you no longer live there. If we were to approve this plan as is, there's already 2 floors with 3 bedrooms in it. And then the basement could easily be another 2 bedrooms. And that's a lot of space for a property in Nutley.
If you maybe, I have, my wife and I, we have 2 daughters. My older daughter, which is his wife, and my younger daughter, who just got married last June, and we planning on bringing her back home with her husband. And as I mentioned before, no strangers are living in the house. It's on the farm.
So you're talking about 3 families living in the house?
But we're gonna use the same apartment, the first floor, which it didn't have enough room. Now we have, with the approval of the board, now we're gonna have 2 bedrooms on the
The plan is for my sister-in-law and husband to move in the first floor of my house, and we stay in the second floor. And what my father-in-law is saying that is that no strangers are gonna come in the house because we're gonna stay with home. And
Well, yeah, you're gonna stay with the home for now, but who knows what happens later on, you know, we can't. This, once we grant a variance, it stays with the property. We can't say to you, okay, if you sell the house, you gotta close up the back door. Once we approve it, it's there forever. So if somebody else comes along later on, well, this is a nice setup, I got a nice basement here, look at the kitchen here, I got a door that goes in. We're making a little apartment down here. You see, the problems have been happening with flooding and things like that, I don't know if your house was, but with all the weather that's been going on, people in basement apartments are flooding out. It's no problem right now, and it's illegal. Listen, I understand that, and you probably would and you will, but we gotta look at this. We gotta look at this as not just for you, but for the future as well. It's gotta last for the next person and the next person after that.
because it will be very difficult for us to put tools, children's toys in crawl space without entrance in the rear. Which is the reason why we decided to make an entrance in the rear just for storage.
Why couldn't you make a full basement? And then enter from the other side? Or enter.
The other side, the other entrance is very uncomfortable.
It's on the side. It's on the side
and
it's by the driveway.
So there's no way to make an entrance to go into the other side of the.
Not from the driveway, no.
No, I'm talking about, you gotta get, how do you get down the basement now?
From the.
From the side.
From the side door.
Right,
And you can either go down to the basement or go up into the house, correct?
correct.
Correct.
Now, once you're down in the basement and you put this other basement in, you can't access that basement? That you're making?
Yes, we are.
Sure.
We're doing a mess.
Without putting a door on the side, you can still get into the basement.
Correct.
So, why do you need another door? You gotta put.
Right, because the existing entrance to the basement is no, something comfortable to go down the basement or go to the first floor. It's very uncomfortable.
Well, the question is basically, the basement can never be legalized as an apartment, because it's a basement. Or in the first place.
Yeah, but you can use that.
It can be used, however, it is a finished basement, it's allowed, you're allowed to finish your basement.
Correct, but if you have a separate entrance
Correct.
where,
Correct,
that's the issue.
correct.
How about a large awning door or something like that? A Velcro door, a awning door.
Bilko?
That was gonna be my recommendation. Set of local doors. Opposed to. Formal entrance. If it's just access to the basement. That's it.
Yes, if it's just access to the basement, a Velcro door.
You want to do basement, from your basement, don't just go to the staircase that goes out. And on top, so you don't put a door down the stairs, you just go up, and then on top, you put a metal cover. You don't need metal cover.
It's back to the inside.
That's what I'm talking about.
You have to have it inside.
Yeah, it's like you open it up. There's the staircase there.
If you don't use it once in a while for tools and things like that, it makes it down, it's extra wide. It's plenty wide.
As a door, that means we will need a variance for that.
You probably need a variance to make the rest of the basement.
The problem is that you were here the first time on a D variance because you were increasing a non-conforming use. Now you're increasing it again, you didn't have permission. The code official pretty much just cited you for the back door. If they were to approve that, it's again increasing a non-conforming use, so you need to put the proofs on for that. Why that's particularly suited and what the special reasons are for that. So are you prepared for that tonight?
Yeah, well, my question is that if, I mean, the Velcro door top of access, you would be okay if this is.
If they
that's
grant
all.
it, it's a D variance, and that's what you're here for. That's part of this,
Correct,
about the rear entrance.
correct.
If you remove the rear entrance, I think it says to construct a full basement and a separate entranceway, so even the full basement is here for that, because again, you were increasing the non-conforming use. This is a business zone and you're putting in residential. So when you're increasing the residential use,
Okay.
it still meets the proofs.
So when you mentioned this is a business area. The apartments in the back, where they have like 20 apartments and buildings. And
I don't know what,
those are bigger.
I don't know, they were approved some other time, right, so.
Yeah, but I'm just,
Whatever,
it's not because I'm gonna.
I understand what you're saying.
I'm just.
But what I'm offering you is sort of a compromise where you would have your full basement, I think, and you would have a way to get tools and things down. You still have a way for people to walk up and down comfortably. They can walk up and down. You're talking about getting tools and stuff down in the basement, if that's what you're gonna use it for. You know, I mean, nobody's gonna wanna rent a apartment, they're gonna go to a building. So.
Is that the bathroom that's down there, is that existing? Is it existing? Was it nothing new in the basement?
That was, that's.
It's existing,
That
old,
was with the house.
old toilet, old tub.
Everything was.
Are you not changing that?
When I bought that house was sort of wrong.
I have an issue with having a separate entrance and a bathroom. I do.
Well, there's not gonna be a separate.
Yeah, it's gonna be the back door entrance.
Bill called door entrance.
Yeah, well, if it makes it a local door,
No, it's gotta be made, if it's approved as a bill call.
and then,
You can't put in a.
so if you have the basement, it'll still be a.
Yeah, we're gonna get in the basement now, you know what I mean? But there's got a way to get in the basement now,
Yeah,
on the side.
I'm just thinking how Clifton also does it, is that if you have the basement like that, they're okay with it as long as you enter it from the first floor, bathroom or or kitchenette, but they don't allow a back door anyway. You have to seal it. So that's what I'm saying, it's giving it a separate entrance still makes it an apartment.
So then you're saying it doesn't matter if it's that kind of entrance or the one we're seeking?
It makes it a livable space. Not that you would, but it could be potentially rented. And now you have 3 families where it's a 2-family. So I'm going to think what Clifton does is you're allowed to enter that basement from your first floor, but you can't have a back door or a separate entrance into it. That's all. Put it out there.
Let's,
I have a question.
get like,
I have a question.
okay.
I know just on, you have an existing storage shed in the back, right, on the property. What do you have in there now, the existing storage shed? Any yard tools or anything like that?
So we have some of the tools there and the rest of the tools I have in storage because now we don't have them.
Well, we had two, to answer your question, we had originally in the back, which was bigger now because the addition was lost space, we had 2 sheds.
So it looks like.
And those sheds were completely
Relocated one.
full, we had to relocate one, and then the other shed we had to get rid of.
I mean, just a suggestion, I know you say like a lot of tools and to put some things in, maybe how big is the shed now? It's not big. Relocate. I mean, is there any room back there to make?
If we put another shed in there, then my kids would.
You would have no space, no space.
No space to play.
All right. Thank you.
Thank you.
Thank you.
Okay, any other thoughts?
Mr. Chairman, I have a question.
Yeah.
So, this basement, that's living space that you use. Sounds like we're gonna be using it a lot, often, and there's gonna be kids and they'll have.
Maybe a playroom in the basement,
Pardon me?
maybe for like playroom for the kids in the basement, that's.
Yeah, I'm looking at the size of the windows and, that's gonna be a space you're gonna utilize quite often. God forbid there's a fire, these windows are small. I'm worried about if it's made into another apartment, that could just be a fire trap as well.
Well, if there's 2 entrances, let's see,
Pardon me?
if there's 2 entrances,
Yeah, but no,
And it's not gonna, as I said before,
to say that you want to utilize it for more.
it's gonna be used only for farming. I don't want to change it.
The problem with putting bigger windows in, it's like creating a.
No, yeah, we have a concern about making it bigger and using
Without
it,
egress.
having a lot more use.
Is there anyone in the audience who would like to be heard for this application? Here you go. Can I get a motion?
Mr. Chairman, I'd like to make a motion to grant the variance for 111 East Center Street, lot 9604-3, based on the following conditions. The applicants asked to add a rear entrance stairs, but the board prefer that the entrance be a set of Philco or barn doors with no external locking mechanism, so it can only be opened from the inside of the apartment or inside of the basement, and for any other reasons that would be set forth by council.
Is there a second?
Second. Who was the second? I can't see. Me. Lord, okay.
All right, the secretary, please call board members. Who's the conditions on this? The,
Philco doors with
Philco door.
no external locking mechanism.
lock from inside.
And only lock from inside.
Perfect.
Ms. Dowery? Yes.
Ms. Haskell?
Yes.
Mr. Chagall?
Yes.
Mr. Gandolfini?
Yes.
Ms. Wallace?
Yes.
Mr. Patria?
Yes.
Mr. Graziano?
Yes. Okay, your variance has been granted with the. Thank you. Okay, 142, Nutley Avenue, come on down. Yeah, but you know. Secretary, you ready over there?
I'm gonna fix it up.
Regarding not to rebuild damaged unsafe garage and installed shed. 114 Nutley Avenue, block 3901/1. Dear Mr. John Tomei, your request for a permit at the above referenced premises to demolish and not to rebuild the existing garage, which was deemed unsafe by the Code Enforcement Department, as shown on the property survey prepared by Shepherd and Shepherd Inc., dated November 2nd, 1992, is denied for the following reason. This property is located in R-1 district, as shown on the Nutley zoning map. Chapter 700, Article 5, Section 700-9A of the Codes of Nutley entitled Permitted Uses in R-1 zoning district states that the following uses are permitted in the R-1 zoning district: single-family dwellings not to exceed one dwelling unit on each lot. No other principal use is permitted on the same lot with a single-family dwelling. Each single-family dwelling shall have 2 parking spaces, at least one of them in a garage.
Thank you. Ready? Spread testimony about the truth, all truth, nothing but the truth. Would you give me your first and last name, spell your last name?
My first name is John. My last name is Tomei, Tomain. 114 Nutley Avenue.
Okay, what would you like to tell the board?
I noticed that this variance, whatever is R1. I looked around, there are houses that are built the same exact time as ours, they don't have a garage. We have a large driveway that accommodates 4 cars. The garage is empty except for a snow blower. We have the landscaper that does everything. We have 3 grandchildren. Just renovated our house twice. It's going to be 100 years old next year, and it would improve the property. It would look nicer. Would give us a little bit of room for the grandchildren to rest about. We believe this is a super serious law. It doesn't, it seems to apply arbitrarily to the town people. You look around, not everyone has a garage. But for us to knock it down and then to be forced to pay to build a new one, I think that's entirely unfair.
What do you plan to do with the space when the garage comes down?
Put a table, eat outside, cook food outside,
Is it gonna be grass or is it gonna be a town?
probably, honestly, probably just pavement.
There's concrete there now.
This concrete, I think we're gonna try to maybe get rid of it. It was never even, the person who did it didn't do a good job, and it sort of water pools up, so we might have to take that.
So when you say pavement, are you talking pavers or are you talking blacktop?
Not blacktop, paved, something that looks nice.
This is an undersized corner lot. only
Yes.
40 foot wide.
It's 40 foot
So,
side corner.
Whatever you decide to do, you may run into an impervious coverage issue. If you're gonna pave.
Can you explain that, what that means? Well,
Impervious coverage, there's a limitation as to how much pavement you can have on one lot.
the whole front lawn is grass.
Yes, but because your lot's undersized, it goes by a percentage, and if you were to, I don't know what the percentages would be, but that becomes a problem, especially with undersized lots, if you go to pave things. It may be 1 for 1, you may be okay, but if you take the garage down, I don't know, you may be faced with another variance down the road if you decide to pave. If you put grass in,
Well, we could put some grass in corner, as long as we don't have to go through the expense of building another building here.
yeah, okay, so
So, I mean, we could do whatever the law says.
All right. Anybody have questions?
We fence in the whole backyard once you knock down the garage.
It's already fenced, there's already a fence there.
But once the garage comes down.
Once the garage comes down, I think we would, but it's the driveway is in the front, just from that driveway section, because they're gonna be children there, there's 3 very small kids. They don't come over.
Put some fence up, maybe back there.
yeah, well, I'm looking, we go by and we take pictures, just so, I don't know if the board wants to refresh their memory as to what it looks like, but another problem is your corner lot. If you continue your fence, you may be back here for about, oh, wait, I think you have it out the back of your house, you may be okay.
I have a
Continue it in
fence.
the, yeah, if you continue it along that line, you're okay. But if you think you're gonna come out and like,
No,
yeah, okay.
Okay, let's just, let's look for just, let's look for about the garage, and as far as impervious coverage, recommend the grass could be put there, but because we have to the code, so we have to
Right.
enforce that.
I just,
So, yes.
we're not telling you what to do, it's just reminding you.
We'll comply whatever that is, it's on the record.
Is your garage leaning?
It's leaning.
Yeah,
It was, David Barry said we had to take it down.
okay.
Yeah,
It can't be fixed, it has to be
fixed.
okay. Anybody in the audience would like to hear say about it? No,
Frank, there's one thing though, are we gonna let him, is he going to continue that fence across and then put?
we have nothing to do with any fencing tonight, and nothing to do with impervious coverage. fencing, if you put some size for fence up, he's gonna go from permit down to the tell he's gotta come back, so. Not gonna worry about
Actually,
it.
if he continues the fence, I think he continues the fence along the same line, because it's behind the house, you can continue from the back line of the house and we're okay.
Because there's already a return on both sides of the fence, so.
So we'll be welcome, it's there.
Yeah,
The
so
code department will worry about that.
they'll help him out
Yeah.
in terms of where he can put it.
Can I have a motion, please?
Well, is there anybody in the audience that wants to speak?
I asked that.
No.
Nobody here?
Mr. Chairman, I'd like to make a motion for 142 Nutley Avenue, lot 3901-1, as per the applicant, to allow them to demolish an unsafe garage and not rebuild a new garage in its absence, given the fact that the owner has a non-conforming lot, there's a limited amount of backyard space, and there's plenty of parking for property already existing for any other reason that we set up like
Secretary of the school board.
Ms. Dougherty?
Yes.
Ms. Castro?
Yes.
Mr. Shadell?
Yes.
Mr. Daniel Toby?
Yes.
Ms. Wallace?
Yes.
Mr. Battaglia?
Yes.
Mr. Graziano?
Yes. Your variance has been granted. Go ahead.
I'm so sorry.
What was the second on that? Oh.
Yeah, I guess the right place.
Right. We have now, next month. Next month, we meet again, we memorialize, we sign it off that it's official, and then it goes down to the building department. And at that point, you'll be able to go apply for whatever you need. You know what, to take it down, you may want to go down, if it's dangerous and it's a safety issue.
Yeah, go see.
You may go see Dave when he's back.
Dave is sick right now, he's not.
And talk to him, he may give you permit to do the demo ahead of the whole one.
I go tomorrow and I give them the preliminary sheets, and sometimes they'll write a permit off of the preliminary sheets if there's good reason.
I want to see now that.
I'm going there tomorrow to tell him,
She doesn't lie.
he gets all the documentation.
Thank you so much.
Have a good
Thank
night.
you. I have resolutions.
Sorry, yeah.
Do we want to go right to other?
We want to go back to, we have to think first, right? Since it's so late, let's try to wrap that up what's going on.
I know, you're, bye-bye, take care. Everybody's here.
Okay, ready? Come on in. I think it's outside. Okay, so,
You want to start your cruise first for this, potentially, however you want to do it?
They lost control of my.
I mean, I don't know how long this is gonna take, it is past what we usually go with something, so let's get started, let's see what we can.
It's 11:07, what time are we?
20 after, we'll see what we got.
Okay, in view of the board's, vote on the, interpretation, our alternative with relief was to request the use variance, because you have determined that the, road D is not an accessory use, and therefore you determined that it is a principal use. And therefore, we are seeking a variance to permit road D under D1 variance to be approved to be used for its current use as a road, and to allow it to function on the lot where it's which you have determined is a lot where it's located, and also to grant final site plan approval for the parking garage on lot one, on block 201 lot 101, 200 lot 101, and also to grant final site plan approval to Road D and to Road H. This was included in our initial submission letter as alternative relief.
Can we don't have Mr. Hay, who is the township planner, to speak to the site plan issue. So if you could just find yourself to the use variance portion for the minutes that the chairman has indicated, we can hopefully work that out.
Okay, with the understanding, just to make clear, it is a final site plan, which means everything for which we're seeking final has been built. And the board, just so to be clear, the as-bills were submitted, they were reviewed, and we went before the planning board initially because we had satisfied the submission requirements.
This board doesn't have any reports about, other than, we have your application, but we don't have any report from Pinoni or I don't know, any other person that has to weigh in on this.
So dealing with this, I don't want to take back our exhibits, but with regard to the use variance, since this would be viewed as a separate application, what we would ask is that we be permitted to mark the same exhibits again for purposes of identifying what the subject matter is. We can, by reference, mark those again, so that would be A1.
Keep the same markings.
The same markings on them, but again, it's for a different application. So I would ask you to refer to them so that we can reference them again, and perhaps put them up. For purposes of the use variance, again, we're just going to ask Mr. Chu to identify the property by reference to the exhibits, and we would ask that they be accepted again as an expert in the field of engineering. Again, this is simply because we need to have the record, and then we'll put on our planning testimony with regard to the use variance.
Okay.
You're already sworn in.
He's still under oath.
Yes.
All right, can you just put your name on the record, and then we ask the board to acknowledge once again that he's been accepted as an expert in the field of engineering.
My name is Dr. Chu, AIA, CHU, employee of Clifford Valley.
And you haven't lost your license since you were last standing up here a few minutes ago.
Yes, ma'am.
Okay. Can you just simply, for the record, identify the property referring to Exhibit A2, which we are resubmitting with this application? Just identify for the record where Road D is located by the color on the plan, and what the other lots are that are on the site, and that's what we would simply ask you for description.
Sure. Road D again is entirely sitting within the block known as 201 lot 1, and then as Road H is within the block 201 lot 101, where is also
1.01, correct?
1.01,
Yeah.
sorry. And where the Metro Garage is known as 150 Metro Boulevard is also within that lot, as well as the courtyard. Now, there's a two existing building that's known as 100 Metro, that's sitting within the block known as 201.
I'm sorry to hear you.
I'm sorry. All right, so there are two existing buildings. One building is known as 100 Metro Boulevard, it's sitting within block 201, lot 1.03. It's highlighted in green color. And there's an existing building of 200 Metro that is located within block 201 and lot 1.02 as highlighted in pink.
And the lot for which the D variance is being requested is the one shown in blue, which you did identify as portion of lot 1 and block 201.
That's
Lot
right.
201. Okay, thank you. I think for purposes of identification, again, moving in all of the exhibits that we previously did for purposes of this. This is, I think unless you have questions for Mr. Chu, that's all we have in terms of the guideline.
I don't, is anyone?
We will call, Dave Novak, our planner.
And just put your name on record again, you're still sworn in.
Good evening, everybody again. My name is David Nova, it's NLBAK with Burgess Associates, professional planning.
And he was previously accepted as an expert in planning. Thank you. You heard the board's determination with regard to our interpretation and their determination that for the road identified as Road D, the private roadway, to be utilized in that capacity, they determined that it is not accessory.
I do recall that, yes.
And therefore, we are seeking the D variance with regard to the use of that property as a principal use because it was found not to be an accessory use. Could you please advise the board what the required proofs are and then present both the positive and negative criteria with regard to this existing roadway?
Absolutely. So as Ms. Gotcha has indicated, now we're at the point of the night where we're requesting variance relief pursuant to NJSA 40:55D-70D1 for a use variance. In order to grant the use variance, I'm sure the board has heard this time and time again, we need to address both the positive and the negative criteria. In regards to the positive criteria, we need to show that there are special reasons for the granting of the variance and that the granting of the variance will further the purposes of the municipal land use law. On the flip side of that, we also need to address the negative criteria, where we need to demonstrate that there's no substantial detriment to the public good and no substantial impairment to the intent of the zone plan. Because we are not an inherently beneficial use, we also have an enhanced burden of proof, where we need to show that the site is particularly suited for this use and that it's not inconsistent with your master planning documents. So to begin with positive criteria and specifically focusing on particular suitability of this use. And based on my review of this application, the site plan materials, I believe that this use is particularly suited due to its specific location here. So to take a step back, we are located within a greater tract of land, which is deemed as an area to be redeveloped by the township of Nutley, as well as by the city of Clifton. It's located within close proximity to redevelopment plans, which would improve both in the township and the city. Most notably, that would include the phase 2A redevelopment plan.
And that's in the township of Nutley, correct?
That is in the township of Nutley, yes. It's also located immediately adjacent to buildings and constructed in conjunction with buildings which were improved and or constructed pursuant to the phase 2A redevelopment plan. That includes 100 Metro Boulevard, which is where Ralph Lauren is. It includes 200 Metro Boulevard, which we discussed tonight with SI Pharmaceuticals. It includes 150 Metro Boulevard, which is a parking garage. It includes an attractive courtyard also between 100 and 200 Metro Boulevard. Thus, due to its location within the overall redevelopment area, the location adjacent to the phase 2A redevelopment plan within the township of Nutley, and due to its location immediately adjacent to uses approved pursuant to that phase 2A redevelopment plan, the site is particularly suited for this use. And I think that is still reflected and acknowledged by the preliminary site plan approval granted by the planning board. So again, it's important to note that the planning board approved the preliminary site plan for this roadway. Specifically, the board approved not only the design of the roadway and its preliminary function, also approved its location. Thus, the township planning board really found this to be a suitable use for this private roadway. This D1 use actually has been triggered to this lot line arrangement. So it's somewhat technical in nature. I don't believe it's been triggered by the location of the roadway specifically in relationship to the rest of the redevelopment plan, but rather due to the issue that was raised during the interpretation aspect of this of how we define lot. The preliminary site plan approval of this roadway also provides further evidence that this use is not inconsistent with the township's master plan. So the Hucknall LaRoche campus was identified as a potential area for redevelopment and rehabilitation back in the 2012 master plan. Actually, it noted that the site was deemed an area in need of rehabilitation back in 2009. That identification was clearly echoed 3 years later after the adoption of the master plan, as the site was later declared an area in need of redevelopment in 2015. The master plan also expresses concern over the closing of the Hucknall LaRoche campus. It expected, and rightly so, a loss of jobs in the facility due to that closing, and it recommended considering redevelopment at the site that's consistent with Nutley's economic and quality of life needs. And in doing so, it specifically placed the priority on Class A office and research purposes. So here, it's again, once important to note that the roadway approved by the planning board will support those office and research uses that are identified and located in buildings 100 and 200. Thus, the master plan, thus this application is not only not inconsistent with the master plan, but it supports the redevelopment efforts approved by the planning board in conjunction with your phase 3 redevelopment plan. Thus, I think we can conclude that this is furthering the purposes of the municipal land use law. Specifically, goal A, which is to encourage action to guide the appropriate use or development of all lands in the state in a manner which will promote public health, safety, and general welfare. Goal G, to provide sufficient space in appropriate locations for a variety of uses, both public and private. Goal H, to encourage transportation routes to promote the free flow of traffic while discouraging congestion. And then goal N, to encourage the coordination of the various public and private procedures and activities shaping land development with a view of lessening the cost of such development into the more efficient use of land. When we look at negative criteria, I don't think we can see any substantial detriment to the public good or impairment to the intent of the zone plan. This is being utilized to accommodate traffic and parking demand from the previously approved buildings. As previously testified by our engineer, this is also providing access into the garage for those who are parking at 100 or 200 Metro Boulevard. It's also providing emergency access around that building as well. It was already in a preliminary function approved by your planning board, and I believe it's furthering the longstanding redevelopment goals established by your master plan, which you've begun to realize through the implementation of that phase 2A redevelopment plan. Thus, my opinion that this application can be granted B1 use variance approval.
Dave, is this a little unusual because it's a use variance being sought for a use that has already received preliminary approval and has been evaluated in terms of its operation and its design?
It is pretty unusual in that regard. Yes, typically when somebody's requesting use variance relief for something that was not granted final site plan approval, typically also wasn't granted preliminary site plan approval as well. It was generally something that was just constructed without that type of approval. This is a different scenario where we did go through those steps, we did get preliminary site plan approval. So yes, I would agree, it's a unique application in that regard.
Okay, and this is again not a speculative assertion as to its suitability for the location, because given the Nutley Planning Board's determination to grant preliminary approval and not to grant final until the improvement is constructed, the efficiency and operation, as he indicated, has already been demonstrated. Correct?
Demonstrated and constructed, yes.
And in terms of why this parcel, unlike other parcels perhaps in the MO zone, although under the law it does not have to be uniquely suited, but there's other MO property in the township, correct?
That's correct.
And this particular piece that we're seeking to be granted a use variance, its proximity to the buildings you testified is one of the things that makes it particularly suitable.
Absolutely, and also you can point to the shape of the lot as well as the remainder of the MO zone in that area as well, which is clearly evident on exhibit A1, which is that blue highlighted area. It's a lot left over in the zoning district immediately adjacent to these buildings that were approved already under the phase 2A plan. So that lot is essentially uniquely designed for utilization of a roadway servicing those uses.
You referenced the master plan, and it's your testimony that that this is consistent and within the contemplation of the goals and objectives of the master plan.
Yes.
Okay. And we spoke previously about the phase 3 redevelopment plan, although admittedly that has been invalidated by the court. However, putting aside whatever other conditions, did the phase 3 redevelopment plan designate this piece of property as a roadway?
Yes.
And did it designate that parcel as an access roadway with the express objective that it served certain parcels?
Yes.
Okay. And actually, it was a number of private roadways that were to serve property in the 2A, the phase 1 redevelopment plan and the 2A redevelopment plan. Was this one of those roads that was so designated?
This was one of those roads, yes.
Okay. So again, that would also support that that there is something unique or something different about this particular piece of property that makes it appropriate to function as a road and access and service these the properties.
Yes.
Okay. Is there any, you stated that there was no detriment to the public road. Is that in part based upon your knowledge of the fact that this has already been approved by the sister board to this board for this particular use?
Yes.
Would it be your understanding that if granting preliminary site plan approval, that the board would have made a determination as to, for example, you mentioned emergency services. In approving a road, would it be a normal incidence of that evaluation that they would examine emergency accessibility?
Yes, absolutely. Turning movements would be provided and reviewed and so on and so forth.
Does the road by its nature at this location, bounded on one side by these buildings that it serves and on the other side by a railroad, does it, in its function as a road, have any other impacts on the adjoining properties that you would anticipate could be viewed as negative from a safety perspective or any other impacts that might be felt beyond the bounds of this particular property?
No, certainly not from a safety perspective, largely also not from a visual perspective as well. So, the roadway is not what we would call very large. I know it is one way extending into the site, and that does turn into a two-way lane. But largely it's not visible from Kingsland Street. And again, based on my opinion, just as a planner, not necessarily a traffic engineer, but somebody who occasionally drives into the roadway and into the site, I would be more prone to go down Metro Boulevard for site circulation as opposed to going down Road D unless I was going to that parking garage.
Okay, and would you, from what you said then in terms of visibility, so that this roadway would be accessed by pulling into the campus at Metro Boulevard and then accessing this as opposed, this has no the road does not directly access, Kingsland, is that correct?
That is correct. It hooks around, connects to Metro Boulevard, and Eastern connects to Capewood.
Okay. Now, does it also connect with Road H within the, Phase 2A redevelopment area?
Yes,
And does that, so does its location also provide circulation with Road H in order to provide ingress and egress from the approved and existing parking garage?
that is correct. And it also provides ingress and egress to the rear of the parking garage on Road D as well.
Okay, and you mentioned that it had been preliminarily approved by the planning board, although there may be some misconception as to preliminary. It was fully engineered to the point that building plans were designed. And to your knowledge, based on your firsthand knowledge, is the road currently existing?
Yes,
And is it currently operating?
yes,
And it provides access to the existing garage located at 150 Metro Boulevard.
that is correct.
That is all we have on the record support.
All right, any questions from the students? Nobody in the office, and oil segment.
I'm sorry, what?
There's nobody in the audience.
It's gotta be.
There it is.
All right, what do we want to do here? So we're looking for preliminary, sorry.
Just the
for,
use
Use
variance.
variance. For this property right now.
Mr. Ricky?
Yeah, would you like to, yeah, chime in?
I'll do that.
1 minute.
I'll be very quick. I'm still sworn, correct?
Yes, you are.
From planning perspective, I think it's clear, there was never the intent not to provide access to the building. That was never the intent. If anything, municipal land use law encourages rather than discourages access. So this application, I think we showed, it really came here on somewhat of a technical jurisdiction issue. But with that said, it was always the intent of the planning board for these roadways to act in an accessory manner. And you say, well, you just said it's not an accessory use, it's a principal use, but what the scholar and the applicant have argued about tonight is that it's really acting in an accessory manner, right? But from a technical standpoint, it's a principal use which created a jurisdictional issue. As a planner, that was always the intent of the board, and to the extent that it continues to act in an accessory manner to those buildings, that will be consistent with the planning board's intent and approval. And I think it's something that should be encouraged. I'm not an attorney, but with all that said, it's clearly particularly well suited to have access to buildings. In terms of the omission of the master plan, that's reconciled because it anticipates access to it. It's just in the manner that it's being conducted related to the negative aspects of the application in terms of it acting in an accessory manner. Similar to how a board may approve a shopping center, and all those private roadways service the shopping center. Here, the planning board wanted those roadways to service the buildings in which they approved. And that's the distinction here. And to the extent that that the board votes to approve it, if you're going to be consistent with that planning board approval, there will be some type of condition to that.
What's the condition?
That I'm not proposing the condition, but
It's not going back to planning board. Once we have a D variance, it stays with us.
well, it's the
For this.
condition's meant to be that the roadways are to be used for the buildings that they were approved associated with.
Roads are to be used for the buildings approved with it.
Well, the roadways for the tenants at 200 and 100 Metro Boulevard.
For tenants at 200 and 100 Metro.
And that was always the anticipation.
Okay.
conditions you would see, needed?
I'm just, in this context, I'm acting as someone that I understand what the intent of that approval was, and we got to a jurisdictional issue that created this problem. But that was always the intent. Okay. And just to further clarify, when the applicant applied to the planning board, when they did apply in their application materials, they applied for those roadways to be used as an accessory use. That was their application at that time. So anything that I'm suggesting is consistent. Is consistent in how we intended and the intention, notwithstanding this jurisdictional issue that came in place that was applied for by the applicant and approved by the plan.
Thank you. Anybody else? Okay.
So are we just voting on
The use variance.
the use variance,
Or road D.
not on site?
Right, site plan, because we need the input from Todd to just say, yes, they fulfilled everything, if that's what the case is or not. And I don't know whether Dick Berry has to weigh in on that. We're not ready for that tonight because we don't have a critical person. Yeah, well, that's final, it's preliminary, so we're gonna have to get that straightened out. But it's just the use variance to approve the road.
So like I said, there's nobody in the audience.
I have a question for Mr. Ricky.
You gotta be sworn in.
I'm happy to be sworn in.
Come on, come on. Raise your right hand, please. You swear the testimony about to give the truth, the whole truth, and nothing but the truth.
I do.
And what would you give us your full name, spell your last name, and your address too?
My name is Eugene Robert Diaz, at 310 Kingston Street, Nutley, New Jersey, 07110. Mr. Ricky, you said it was the intent of the planning board to, our word, it was not the right word, restrict or limit the use of the road to the properties over there, is that correct?
Yes.
Were there in the preliminary site plan approval, let's take road H as an example, which was approved of that, did the planning board put any limitations on the use of that roadway?
The limitation was that it would be accessory to the buildings. When you applied to the board, you applied for it to be an accessory use. That road.
Doesn't the board wants to limit something, don't they put a specific limitation on its use? Such as you're asking, you can just open the door for this zoning board here to do here, but there is no such limitation from the planning board on the use of road H or the other roads, are there?
To be used by the buildings was the limitation. That's what accessory.
It says that in the approvals, because I don't believe there's any limitation in the approvals.
That's my interpretation of what the word accessory means, because an accessory use is something that it has a relationship is symbiotic with and works with the principal use of the project.
Thank you. All right. I guess we're looking for a motion at this point.
Mr. Chairman, I have a motion to approve a D1 variance from the Nutley Township Code, section 700-21, to permit road D as a private access roadway as a principal use for the separate lot designated as block 201 lot 1, with conditions that the roadway be used for the tenants of 100 and 200 Metro Boulevard and any other conditions set forth by county.
Secretary, please call the board.
Ms. Dougherty?
Yes.
Ms. Castro? Yes. Mr. Shidewell?
Yes.
Mr. Daniel Toby?
Yes.
Ms. Wallace?
Yes.
Mr. Battaglia?
Yes.
Mr. President?
Yes. All right. To be continued. We got other business, Diana?
Yes, let's do
Okay,
it.
I'm sorry, I just wanted to confirm that the next school lease is going to be using that building. That's all. And that lease is.
That's cool.
I said before that the town had amended the redevelopment plan to that the next school students use the deck while their deck was being built. I wanted to make sure that they were out of there, the lease was over, otherwise they wouldn't be able to get out of the deck off the road.
All right.
Are we done? Thank you so much.
Okay, right. All right,
Do we need to carry this with the site plan without the
okay, yes, site plan will be carried to the January meeting, but I'll have to talk with you because we have a big variance in here. We may be carrying it again, but we'll see,
Okay, but for purposes of no further notice, we can carry it to a date certain time.
Yes, the next meeting is
January
January,
10th.
It was the, it's.
next regular meeting. January 10th.
I thought you said, oh, you said 2022, I thought it was January.
January 2022,
Yes. All right, so we need a motion to carry this?
just the site plan.
Site plan, do I have a second, do I have a motion?
All in favor of carrying the site plan?
All in favor? Aye. Opposed? It's moved. Okay.
Okay, we have, maybe we see last. We have minutes from November 15, 2021, recorded from board members. Does anybody have any corrections, additions, or changes to those minutes?
I'm excused, is that okay, buddy?
Yes.
Thank you very much.
Any changes, corrections, or additions to those minutes? All right, now could we have a motion approving those minutes? Okay. Okay, resolutions, proponent Federal Credit Union, 433 and 409 Kingston Street, block 2304, lots 15 and 16. Victoria Joaquin Ortega, 35 Edison Avenue, block 2401, lot 43. Parent Street, 76 Evergreen Avenue, block 7302, lot 17. Mr. and Mrs. Matthew Aiello, 96 Edward Lane, block 3602, lot 30. Emma and Jose Francisco, 88 Clayton Avenue, block 2400, lot 19. Mr. Michael Hassan, 18 Maple Place, lot 2304, lot 25. And that's it, the resolutions from the meeting that was held on our November meeting. So, we have a motion to approve those resolutions. All in favor? And our last bit of business is thanking Ms. Atola McGuire for filling in as our board secretary, approving her pay of $150. I have a motion approving that. All in favor? Aye.
Ready? Couple more things. Number one is thanks everybody for putting a little extra effort into tonight. I want to thank Joe Tackney for his time on the board. And we should go. Good luck on the Board of Education. The third reading.
I think I'll have more children just to go in front of 4 days. No, we don't want to do that.
Everybody have a nice Christmas. Huh? See you back here.
Happy holidays.